Welcome to our November 17th Douglas County Board of County Commissioners business meeting. We want to welcome those of you who are with us in the Douglas County Courthouse, as well as those of you joining us online via Zoom. We just want to pass on a bit of information regarding how we'll run our hybrid meeting in person and on Zoom in this time of social distancing. Each action item will have an opportunity for public comment. If you would like to make a comment on that item, we ask that you wait until that item on the agenda. The general public comment portion of our agenda is for items not on the agenda, but related to general county business. All public comments should be directed to the County Commission. For both opportunities for public comment, we will take public comments from people who are in person in the courthouse first, and then online commenters. All public comments will be limited to 3 minutes. If you have a public comment on an agenda item or under general public comment, please use the raise your hand function on Zoom. Staff will call on you and unmute you. We ask that speakers give their name and addresses for the minutes. The county reserves the right to shut off the microphone and remove any speaker from the meeting if they are vulgar, rude, or inappropriate. If visual aids are used during the meeting, the presenter will share the screen with the call. Participants will not be able to view them without a computer, smartphone, or tablet. All participants will be entered into the meeting with their audio muted, meaning the commission and the public will not be able to hear you. Presenters will be unmuted when their agenda item comes up. We ask that all online presenters use good conference call etiquette and mute their line when not speaking. And please introduce themselves each time they do speak. A recording of this meeting will be available on our website after the meeting. We will start with our consent agenda. Would either of the commissioners like to pull anything from the consent agenda? No. Would anyone in the public like to pull anything from the consent agenda?
Commissioner Reed, I move to approve today's consent agenda items 1.1 through 1.3.
Second.
All of those in favor, please say aye.
Aye.
We will move on to general public comment. Just a reminder that if you have public comment on an agenda item, please wait for that agenda item. Do we have anyone in the courthouse for general public comment? Do we have anyone online for general public comment? Okay, we will move on to our regular agenda. We will start with item 3.1 from the Planning Department. Consider a comprehensive plan amendment. Sarah?
Commissioners, I believe we're moving Mary Miller from Lawrence Douglas County Planning into the panel.
Good evening, Commissioners. Mary Miller, a City County Planner, and I'll be sharing my screen. This is a comprehensive plan amendment requesting to change Chapter 8B of the comprehensive plan, which is the section with the long-range area plans, specifically to change the recommendations in the west of K10 plan. The graphic on the left shows the boundaries of the area west of K10 plan. It's primarily west of K10, although there is some property that does extend to the east, down in the southeast corner. This is all located outside the city limits, except for the subject property, which is highlighted in yellow. And this was annexed into the city of Lawrence in 2012. The graphic on the right shows the future land use recommendations in the planning area. The subject property is being recommended for community commercial center. That's the red and yellow striped area. And along the north, there's a strip of open space buffer that's being recommended. And that's to provide a buffer for that existing rural residential subdivision to the north. The other uses that are being recommended, the yellow is low density residential. The orange is medium density residential. The tan area is residential office. And the dark brown area is high density residential. The blue area is institutional. And south of the subject property, there is an existing church in this area. Purple is in industrial. And the solid red is just commercial. And I think those are all the land use recommendations in the area. And the plan notes that the community commercial center district is intended to allow for commercial, office, mixed use, residential, and employment uses. And that up to 600,000 square feet of retail space is to be located at this intersection. And the plan divides it into by nodes. So the northwest corner of the intersection is allotted 155,000 square feet of retail. However, the northwest corner, the plan does not recommend any standalone residential uses as it does in the southeast corner. Low density residential is recommended in the southeast corner, and it is developed with low density residences now. The zoning districts that are recommended for this corner permit residential uses. They only permit multi-dwelling residential uses, and that is when they make up less than 50% of a development project. And so there's limitations on the type of residences that are permitted now. Plan 2040 recommends that residential development occur in Tier 1 of the city of Lawrence before we annex land for additional development. And so it recommends infill development. In this case, it's very unusual that we have a large area of greenfield that has not been developed. So additional residential development could be accommodated here, then would be possible with traditional infill over another area. Achieving a mix of residential uses in this quadrant would require the revision to the area plan to allow various residential types, as well as the multi-dwelling uses that are permitted as part of the mixed-use retail commercial projects. The applicant has requested that low and medium density residential uses be included in the recommended uses for this northwest corner of the intersection, and that the future land use map be revised to show these. The current recommendations are shown on the map on the left. The map on the right shows that being proposed with this amendment. The commercial area is lighter pink, but it's the same commercial area. Area of low to medium density residential is being proposed in the corner. This would be adjacent to that residential neighborhood to the north and would provide a transition between that and the commercial area. And the open space is proposed to be widened, and this would serve more as an open space amenity as well as a buffer. This contains a drainage way now and will probably be a place for stormwater detention. So whether it's a visual amenity or if it could be developed with trails, that would be determined when the engineering is done and when this property is site planned, but it would provide a larger area of open space. And then the existing buffer area that would be retained on the east side. And these figures show the recommended land uses overlaying the existing land uses. So on the left side, you can see the community commercial center and the buffer strip. And the buffer strip does provide buffering for that residential neighborhood to the north. There is a low density residential or single family residential property to the west, which is not buffered, but it is quite a distance from the property. The graphic on the right shows what's being proposed, and that does put residential adjacent to the single family development to the north and to that single family to the west. It shows the open space buffer. So we have quite a buffering area between existing residential uses and the proposed or future commercial uses. There is no recommendation for a buffer area along the new residential area because as this is a greenfield, we would take that into account when it develops. When the residential property is platted, it would be platted considering that there would be commercial next door. And our commercial developments in the city have to comply with the commercial design guidelines. And these have, they have recommendations that not only improve the aesthetics of the community commercial center, but they are intended to make them compatible with other less intense land uses. For instance, the massing and scale of the building would be required to be less when it's closer to a lower intensity uses. Actually, the lower intensity uses would be recommended in that area as well to be compatible. Lighting and landscaping would be looked at, as well as the orientation of the buildings. The community commercial design guidelines expect the properties, the different developments to be so compatible, they actually encourage that they be integrated to a degree, that there be walkways so that it's able to go from one to the other. And if there's fencing, that it be transparent fencing rather than something to block the view. This change to the area plan would require two things. One is a change to the map, and the other is some changing to the wording. So as I mentioned earlier, on the left side, we see the recommendations that are currently in the plan, and on the right, you can see what's being proposed. And we looked a moment ago at how that would be considered in view of what's on the property now. And if you take it into account of what's being recommended in the future, well, we have the low density to the north. It's not in the area plan, but that would be considered to be its future use. We have medium residential density to the west. And so the proposed residential area would be compatible with what's being recommended in the area plan for other areas. So the change to language, while we're showing the yellow as the low density residential, it could be low or medium density. RS7 is a zoning district that's being requested, and that's just a little over 6 dwelling units an acre. And 6 dwelling units an acre is the limit between low and medium. So the wording doesn't specifically call out if it's low or medium density. That way either one is an option. However, the language currently notes that that intersection, the northwest corner, is expected to have a mix of uses, including retail and other commercial uses. So we're recommending adding the wording that residential uses may be incorporated as components of a mixed commercial development or may be developed independently along the north and west boundary of the corner. This area is intended to be a commercial node, therefore residential should be limited to maintain the retail character. And so the intent is to allow residential, standalone residential to be provided, but also to limit it. So this area does still remain a community commercial center. The Planning Commission considered this amendment at their September 22nd meeting and voted 7-1 to approve it and forward it to the commissions, the city and the county commissions, with a recommendation for approval. And the City Commission considered it at their November 9th meeting and voted unanimously to approve it. However, its second reading has not gone before the commission yet. It will be before them on December 7th. And so they'll make their final vote at that time. And so we'd be asking you to approve the amendment and adopt the resolution, but the resolution will be back to you for signature later when the City Commission has made their final action on it. And the CPA process is a little different than anything else that we do. It's required to have the approval of the Planning Commission, the City Commission, and the Board of County Commissioners. If any one of those bodies votes to deny the amendment, that's the end of the road and it doesn't move forward. However, the rezoning requests can move forward independently of the comprehensive plan amendment. It is just one of the review criteria. So we would take everything into account when reviewing the rezoning request. And if it seemed reasonable and if it just didn't comply with the area plan, it's possible that it could still be approved. So that concludes my presentation, and I think the applicant is present today.
Do we have any questions from commissioners?
No questions from me.
We will open this up. Is the applicant wanting to say anything? Okay.
Matt, you're in the panel if you want to provide comment.
Good evening, commissioners. Thank you. I appreciate the opportunity to speak with you. This process began as a component to the rezoning applications that the Planning Commission and the City Commission considered and voted for approval. The property itself is located entirely in the city of Lawrence. The proposed amendments to the comprehensive plan are very consistent with Plan 2040 because this project would promote the development of tier 1 properties before going to tier 2 for any new residential uses. We stand with the staff and ask for your recommendation of approval, and I'm pleased to answer any questions that you may have.
Matt, could you introduce yourself for the record, please?
Yes, I apologize. My name is Matt Goff with Barbara Emerson Law Firm, 1211 Massachusetts Street.
Thank you very much. We will open this up for public comment. Do we have any public comment on this item in the courthouse? Do we have any public comment online?
Kirby, I'm going to move you into the panel in just a moment. Kirby, you can go ahead and unmute and offer your public comment on this item.
Was this about the holistic defenders? Sorry, I've been a little
No.
distracted.
It's not,
Sorry.
sorry.
I'll put my hand down then.
Okay. Move your hand down. Okay,
We
sorry.
will bring this back for discussion amongst commissioners. Commissioners?
So I'm excited to see this proposal as we continue to think about how we're going to expand as a community and provide housing. This is, as Mary mentioned, very in line with Plan 2040. And we've asked the planning department for some help with some area plans. So Mary, I appreciate the work on this and getting this done and getting this to the commission so that those who live in that area can understand what our intentions are going forward. So thanks for your work on that.
This is Commissioner Reed, I would echo that and also appreciate, Mary, that you've had to do this a number of times because of the uniqueness of this process and coming before multiple bodies. So thank you for all that extra time and labor. So I move to approve a comprehensive plan amendment CPA 21-00258 to Plan 2040, amending Chapter 8B in the West of K10 plan to add residential uses to the list of recommended uses for a portion of the northwest quadrant of the intersection of West 6th Street and Kansas Highway 10, based on the findings presented in the staff report, and adopt ordinance number 9882, resolution number 2149.
Second.
All of those in favor, please say aye.
Aye.
Thank you. Thank you, Mary. And thank you, Matt. We will move on to item 3.2, review proposals for institutional misdemeanor public defense. I can give a bit of background on this if you all would like. So as we start this discussion, I do think it's important to recap how we got here. For as long as I can remember, in Douglas County, at least back to the turn of the 21st century, here in our community, we've had on and off again conversations about a public defender's office. More recently, criminal justice reform conversations were a prominent part of 2020 and were an important part of our local campaigns, particularly for county commission. While campaigning, I was also appointed to Governor Kelly's Commission on Racial Equity and Justice. We spent significant time discussing criminal defense and ultimately recommended that every community in our state with more than 100,000 residents, including Douglas County, have a public defender's office. As soon as I took office in 2021, I sent a formal request to the Board of Indigent Defense Services to request that bids consider opening an office in Douglas County. They explored that possibility in 2021, including hosting a public hearing, and it was clear that our community was interested in institutional public defense. They voted in favor for opening an office that would handle felony public defense, indigent defense in our community. That's pending legislative budget approval. Kansas is unique. Most states have the same mechanism for funding felony and misdemeanor indigent defense. Kansas does not. Felony indigent defense is paid for by the state, while misdemeanor indigent defense is paid for by the county. The county has traditionally used a panel system to pay for this, but the county received a proposal for a nonprofit misdemeanor office as part of our standard community partner funding cycle. There's no call for community partner budget requests. The commission considers all requests that come from local nonprofits. The proposal we received was submitted by a community member who also volunteered on my campaign as well as Commissioner Reed's, but he developed the proposal separate from our campaigns. Knowing that indigent defense is an important part of the criminal justice reform work that the county was participating in, the county established an indigent defense work group, which included the leader for the nonprofit proposal, as well as current panel attorneys who work in criminal defense in our local community. While the work group was doing its work, the commission considered the KHD Kansas Holistic Defenders proposal as part of our public budgeting process this summer. The commission set aside funds for a misdemeanor defense office, but decided to hold off on allocating it to KHD while the work group finished their work. A work group that includes community stakeholders, including nonprofits that receive funds from the county, is a standard practice in our community. We have groups working on homelessness and housing issues. We have a work group with Bert Nash in the Lawrence Memorial Hospital, working to develop the Treatment and Recovery Center. The Indigent Defense Work Group that had local attorneys as well as KHD continued to do their work. And while we had known that the KHD proposal was on the table throughout the work group's time, We didn't know that private attorneys who were working on the work group were also preparing a separate proposal. Since this proposal came in late in the process, we realized we don't have a process to consider two competing proposals, particularly one from a nonprofit and one from a for-profit entity. The commission decided 2 weeks ago that we would consider both proposals and use the same process that we used for our budget hearings this summer. That means that we won't have presentations from the two proposals, but commissioners will have the opportunity to ask questions of representatives from both proposals. And then we'll open this up to public comment so we can hear from our community. The commission will then discuss. So we'll start with commissioner questions.
Do you want to start with questions in general, or should we start with particular proposal?
What is the preference of commissioners? Side by side or one proposal at a time? This summer, we did it in kind of groups and clumps. So it was about a particular topic, so I can see either way. If we'd like to start with one at a time, shall we start with KHD and then Douglas County Defense Services? Take them chronologically? Okay, so one at a time?
Yep.
Okay, we'll start with questions for Kansas Holistic Defenders.
And Sam, when you get up there, if you could just touch the button and it'll turn the little light green. And you should be good to go.
How's that?
You gotta talk right into it.
Need to turn it down a little bit. Good evening, commissioners.
I don't mind starting. Yeah. So Sam, thanks for being here. I have a question about the client advocate, and the concern has been raised that if Kansas Holistic Defenders is conflicted out for some reason, that client advocate services would not be provided to those clients who could not be working with KHD because of the conflict. And that might create an inequitable situation in front of the courts. How would you address that problem?
Well, there's two, I want to answer it in two parts. First, I want to talk about what this looks like in other jurisdictions. And then I want to talk about what we can specifically do to address that here. This is a feature of all indigent defense systems, that there are differences between the people who, the services that people receive when randomly allocated from one provider to another. That's true if you have panel attorneys, some of whom may be solo practitioners, some of whom may work in a large firm. This is also true for every system of what we call a hybrid system, which is what we would have here, in which you have an indigent defense provider that has a team of people working together and a panel of attorneys. It's never been a constitutional issue in any other jurisdiction. It's a normal feature. The way that we can deal with that here, and this is something that we put in our supplemental letter to the commission, is that it's not by reducing the quality of services that some people receive, but rather to work to improve the quality of everyone's performance across the system. This is something that we see the federal defenders do really well. So for instance, the federal defenders will represent most people charged with federal offense. And then there's what's called the CJA panel, their panel of attorneys. Now, the federal defenders will take calls from attorneys dealing with certain issues that might affect a client that might be niche, that attorney perhaps hasn't dealt with before. They might help make referrals where appropriate. If an attorney says, hey, I'm on the CJA panel, but is there an immigration attorney that y'all would recommend? Is there access to services? So within the federal system, you see helping make those referrals as well. They also have a training program called Second Chair, in which people who are admitted to that panel train up with the federal defenders to better understand the system. And the federal defenders also embraces a holistic ethos and how they go about this. So I think that they'd be a really good model. What that means here is, I think, a few things. I think one, we, like all good public defenders' offices, would be welcoming of when a panel attorney reaches out looking for assistance. Now, the conflict of interest rules say that we wouldn't be able to discuss the case. But aside from that, right, like the question of, hey, where, what are the requirements for accessing the Kansas Emergency Rental Assistance? I've got a client who's about to be evicted. Be happy to help that. The second feature that we would also be doing would be training. So for instance, when we train up all of our people together, ideally in January, we would be making slots in those trainings available to panel attorneys, but also to attorneys at bids and also to KU law students. I mean, not to all of them, but to, puts those slots in. Good public defenders offices also extend trainings and CLEs to people to raise the ability of even solo practitioners, panel attorneys to access those resources. So it's not a perfect solution. I mean, again, there's nobody who's figured out how to make every single indigent defendant get the exact same quality of representation, no matter who represents them. But indigent defense providers have been able to ameliorate that to a great degree through those strategies, and I think we would do the same. Does that answer your question? I'm sorry.
I think so. I'm going to say it back to you to make sure I understood what you said. So the client advocate that works for Kansas Holistic Defenders can work with any panel attorney. Is that what you told me?
Unfortunately, no. I mean, not in the same way that one would have, like, be providing services. The reason why is that that client advocate is part of the defense team. They're therefore, beholden to the same conflict rules that would apply to attorneys. A client advocate would only be available for attorneys of KHD. But it's worth mentioning what the client advocate does in the Partners for Justice model. In some ways, some of the things that a client advocate does are already things that a good attorney does. If I have a client who's being evicted, I'll help them get signed up for KIRA, right? If I have a client who needs to get into the Willow Domestic Violence Shelter, I'll pick up the phone. The advantage of having a client advocate is not necessarily that they do something that an attorney can't do and doesn't do, but rather that by having a specialist whose job is to just do those things, it frees up the attorneys to focus on the areas that you do need a law degree to do, right? Litigating the case. And so, no, a client advocate would not be able to, be on the defense team of somebody who we were conflicted off from. But in terms of providing training, providing input, we believe that we could make sure that it was possible for panel attorneys to do many of the same things that a client advocate would do, and with the knowledge that comes out of that specialization, we'd be happy to share with others.
Okay, so the client advocate can't work for that client if they're not being served by Kansas Holistic Defenders, but they can provide training for the other attorneys.
That's right. So, for instance, one way that this works is if there's somebody who is representing a party that's conflicted off, we can't advise them on how to best litigate their case. But if somebody calls in and says, hey, what is your understanding of the law as it pertains to search and seizures of cell phones, right? That's information similar to where, there's a new program that's coming out. How do we get on the NAMI mental health services that are rolling out? What do you know about those? That's all things that we could collaborate on and would. And again, this is a normal feature of a thing that public defenders' offices all over the country do all the time.
Okay, so was there any consideration for just there being a Douglas, maybe not through Kansas Holistic Defenders, and this may not be a good question to ask you because you provided us a proposal, but it's just And in fact, you may not want to respond to this at all, but if there was any consideration to just providing a client advocate that would serve all misdemeanor cases.
That's a very interesting proposal. So, and I don't want to get into too far into fantasy, but what I can say is that, for instance, you know, if there was to be like a managed assigned counsel program, similar to the CJA panel, Laura Schoenfeld runs the CJA panel on the federal level, and will, you know, make sure that people are using investigators and are hiring investigators, and has a pool of those that are available, right? That's something that could exist with a client advocate. I don't know of any jurisdictions. Well, that's not necessarily true. So in Harris County in Houston, Texas, I believe that they have where they rely very extensively on appointed counsel. I believe that they've started looking into like making social workers available to panel attorneys. This is part of the resolution of a huge number of changes they've made in their system. I don't have any research on how that works exactly, but I know that it's something that exists generally and is starting to be tried in other jurisdictions in which there's dedicated support staff for the panel. We wouldn't be doing that in this proposal, but I think that's a conversation that we could definitely have as this process develops. Did that answer your question? I'm sorry.
So as part of our budgeting process, we talk a lot about equity, and there were 2 equity questions that we asked all folks asking the county commission for money. Can you tell us a bit about how your proposal would focus on advancing equity in our community?
Yes, and I would like to just refer to the a presentation that we did for the work group specifically on this question. And we've also submitted memorandum to the work group on this question as well. I believe that the commissioners have that. But public defense is fundamentally about advancing equity. It is a vision of a system of equal justice for all, regardless of the socioeconomic factors that may limit people's access to justice. So this is not only deeply rooted into the history of public defense, it's also something that's happening in a live conversation within the profession right now. So the National Association of Public Defenders just had 2 weeks ago a retreat, and that was a significant training on specifically how public defenders can address specifically racial disparities. And in the context of Douglas County, what that looks like is we do have significant racial disparities particularly in our misdemeanors. I'm just going to pull up my notes on that so I can quote that accurately. So in 2019, Black people who make up 16% of the misdemeanor only bookings in the Douglas County Jail, they make up 4% of the population of the county. There's a stark disparity. There are disparities for Hispanic people who are less likely than white non-Hispanic people by a significant margin to not be released on their own recognizance. There's stark disparities for Native Americans. And that's just on the face of the charging and outcomes and bail bond decisions that are made. There's a whole nother area of racial disparity in our system, which lives in the collateral consequences of arrest and prosecution, right? So for instance, if you have employment consequences in the sense of having the way that a misdemeanor can affect someone's criminal, the way that having a misdemeanor can affect someone's ability to get employed, data suggests that the effect of having a criminal record makes Black applicants 60% less likely to be hired, less likely to be hired than similarly situated white applicants who also have a criminal record. Racial disparities exist in housing and eviction can be a consequence even of a misdemeanor conviction. It's legal under Kansas law to discriminate against somebody on the basis of having a misdemeanor drug conviction in housing. And we also see eviction follows a stark pattern of racial disparities as well. So what can we do? There's given that that is the context that we're in. The first is that we should look to what we can do to change outcomes generally, right? To reduce the impacts of these underlying systems of racial disparity, right? So reduce the degree to which these racial disparities impact on somebody's life. This is partially where the research on the differences between institutional public defense and appointed counsel comes into play. The research that has been done in jurisdictions all over the country shows that institutional public defenders are more likely to, on average, to get their clients released on their own recognizance, have shorter jail sentences for their clients on average, have higher rates of success on appeal on average. And all of that has consequences for the pre-existing racial disparities, right? So if we have attorneys who are operating on a team, who are trained together and who can appear at first appearances and make these arguments, then we can start to push back on the implicit bias and the other forms of injustice that create the racial disparities that we see at the setting of bonds. So that's one category of way that we would be able to deal with this. Second category that I would talk about is the downstream consequences, right? So misdemeanors are not minor insofar as the effect that they have on someone's life. Everyone who's got a really long criminal record was once a person who had no criminal record. And the first time they got a criminal record, most of the time it was a misdemeanor. So how that misdemeanor was handled, then trickles down to every other future interaction that they're going to have. In the Kansas sentencing guidelines, your sentence for a felony was going to be enhanced depending on the number of misdemeanors, right? So the difference between a dismissal, the difference between getting that expunged or not, also is a driver of the racial disparities that we see even in the felonies, right? Where you see significant disproportionate over incarceration of folks of color in the justice system, right? So handling misdemeanors correctly and in the best way that we can has an impact for those downstream consequences. And the last one was, as I said, the collateral consequences, right? The non-criminal penalties that happen as a result of conviction. If we have an office that operates on the holistic model and that pays a lot of attention to those, we can start to push back against those. And those are some of the areas where we see the starkest differences in terms of the results of the criminal legal system by race. So knowing that there is a potential collateral consequence for housing and seeking a resolution to the case that avoids that consequence, being able to pay a lot of attention to how this might affect educational collateral consequences, having a client advocate that can help get better access to services. And again, disparities in the access to services also has a racial component. All of these things, by targeting those collateral consequences, we can reduce the impact of the amount of disparity that these disparities have. And the last piece, and I know I'm going on about this, but I think it's very important, is the systemic level, right? Because, and we have to think on the systemic level here, right? Not just the question of an individual attorney, right, in comparisons, because these are systemic issues. And on the systemic level, this is also where an institutional public defender really has a lot to do. So there's been public defenders' offices all over the country that have started to litigate either through lawsuits or through motions to suppress or through collaborations and public partnerships, specifically addressing the issues of racial disparity that they're seeing affect their clients. And so having somebody who is an institutional partner who can be a seat at the table for when these discussions are happening, to collect the data of how these things affect our clients in a way that frankly, no one else in the system can really collect in the same way that a public defender can. All of those have led in many other jurisdictions to public defenders' offices being able to intervene on the systemic level and reduce the impact of racial disparities that way. I'm sorry to have gone on, but it's an important issue to me, and I hope I've answered your question.
Hi, Sam. This Commissioner Reed here, I could check off a couple of questions. Thank you, fellow commissioners. I'm curious, so I had some conversations in recent month, well, throughout the year about the number of attorneys that KHD intends to employ, which is currently at 3 in this proposal, with the support staff and that team-based approach that is the holistic model. Can you talk a little bit about your understanding and sort of what the intent behind KHD's caseload management will look like, what your expectations are around that, and also whether or not your office would be participating in any other type of legal practice outside of the indigent misdemeanor appointed counsel through district court, any other type of civil litigation or other contracts or practices that you intend to do outside of this proposal.
Okay, I'm going to take that question in parts. I'm first going to go to the question of caseloads. So the ABA caseload standard, right, is no more than 400 misdemeanors handled by an individual attorney at a time. I believe that that's too high. And there's a significant discussion happening within public defenders' offices as to what the new numbers should be. So the Texas Indigent Defense Commission, that is the statewide body in Texas that's been leading the charge on revitalizing and revamping how they do this, recommends caseloads of 236 misdemeanors per individual attorney per year. Anecdotally, that is actually much lower than is the caseloads in most public defenders' offices, and certainly is something recognized within the profession to be a manageable number. As far as how many cases we would actually be handling, it's going to depend. Of course, we've seen a dip in the number of misdemeanors as a result of COVID, and it will also depend on how many conflicts exist, right? Additionally, how many people are qualifying for indigent defense. We can say that in the last 4 years, we've seen about 75% of people qualify for indigent defense. And so assuming that we get about 500 cases in the system total, with 500 indigent defense cases in the system total, and assuming about 15 to 20% of those will be conflicts, which may be high. I don't think that would be a low estimate. We're looking at well under 200 cases per attorney per year. This is something that can be arranged as part of the contract as well, right? Like, obviously, if there was an unforeseeable leap in the number of misdemeanors and we got above that, we would have to ethically, pass those cases on to the panel. I think that would be the right way to handle that. But based on the numbers that we're seeing in the system right now, we would be well under what any standard of a case cap would be based on the volume that we're dealing with. So secondly, are there other forms of involvement that we may be in? The short answer is no. At a public defender's office, your attorneys are generally not allowed to handle matters outside of the course of that employment. However, there's 2 areas that we would like to explore being able to represent people in. So one would be if somebody was our client on a misdemeanor and subsequently was charged with a felony, we would want to be on the panel to receive the bid's representation for that case. The reason being that you maintain one lawyer, right? If somebody has two cases, you don't want them to have two lawyers, you want one lawyer. But that I think would be overall a relatively low volume of the cases overall. And then the other area is, would we be engaged in any other kind of legal representation? We would want to reserve the right to be able to provide pro bono services to our clients outside of the context of their misdemeanor case if we felt that it was in the interest of serving our holistic mission, right? So a good example of this might be in a DUI case. There's often an administrative proceeding to revoke somebody's license based on whether or not they blew. That has tremendous collateral consequences for them. A private attorney routinely handles that administrative hearing as part of the representation when you take on a DUI case. We would want to do the same because, again, they have rights in that hearing. They are unrepresented. The consequences of having a license revocation, perhaps done wrongfully, could be devastating. So we would want to be able to handle those cases or those sort of other collateral consequences, but it would still be for the same client. The last thing is that we are looking at being a site for a civil legal attorney providing case support on a referral basis as part of a pilot program. This is something that's still in the future. It would be somebody who would not be doing the work of representing people on misdemeanors, not one of those three attorneys separately hired. But a lot of offices do have like civil practices that they also make available either to their clients or to other forms of referral on a pro bono basis. That's something we would want to look into. But as far as the work that the three criminal defense attorneys were doing, it would be limited to practice solely for our appointed clients or other work for them on a pro bono basis. Does that answer your question?
Yes, thank you. So can you talk to us a little bit more about procedurally, and maybe you, over the course of the months, maybe there's been conversations with the district court that have discussed what the procedures of dealing with conflicts would look like. So, you know, a misdemeanor case is charged, a financial affidavit is submitted to the court, they're deemed eligible for indigent defense. If they were to be appointed to KHD, sort of off the top right away, because that's the default of the court and everything, can you help me understand procedurally what happens in your office to determine the conflict? And then if there is a conflict identified, maybe in different situations, because I know sometimes the conflict is present right away. There's co-defendants and that's sort of dealt with immediately. Sometimes a conflict is not necessarily discovered until a full list of witnesses and victims and more information is provided. So can you help me get to kind of the nuts and bolts, if you know them yet, of what that would look like and how that would go back to the court for appointment to somebody on a conflicts panel? Have you had those discussions?
Yes. So I'm going to answer this one in a couple of parts. First, what do we do to detect conflicts? When do we meet with the client? How do we get in the case? Is the first question, right? And then the second would be we're working with the district court to sort of implement this. And I would also tag our sheriff as well as having a role to play in this that I'd also like to discuss. So going to the question of how conflicts are detected. So as part of the case management system, the electronic case management system that we're using, every time we get a case, and throughout the case, every time any person is involved with the case, we make a record of that person's sort of existence and involvement. So when we get the witness list, all of those people would be entered in. all of the officers involved would be entered in. Anybody else who's a service provider would be entered in as part of this database. When we get a case, essentially what the case management system does is we take the name of that person who is who's the defendant, and we would run it against the accumulated list of all individuals we've ever encountered and see what their role in the case was to determine if there is a conflict, right? And so that happens, the way that happens in the case management system is a little button pops up when the name is put in, it says potential conflict detected, right? And that just tells us that this person has been present in our system in a way that means that we need to do further investigation. And that can happen even before we meet the client, right? So in the morning, the sheriff has a list of people who are in custody. We have the dockets that are going to be the names that are on the first appearance docket for that day. We can already start running those names, screening out people where there would be a conflict. If there isn't a conflict, being able to, we want to create a system in which we can meet with them actually before the first appearance. There's a couple of ways to do this logistically. One of these might be getting the indigency determination form filled out at the time of booking as early as possible in the process, with a checkbox authorizing it to be released to us for the purpose of getting in early into representation, right? Once we had that, we could see the indigent defense form and say, you know what, it looks like this person's going to be eligible. We have a good reason to believe that we will represent them. We can approach them and ask, would you like to speak to us for the purposes of representation, either at the jail or at the courthouse, depending on where they happen to be, to meet with them before that first appearance. And it's really important to meet with people before first appearances, because first appearance is where the bond is decided. And so it's very difficult to make a competent bond argument for somebody that you've never met and have had no interaction with. Whereas if you can meet them some point before and be able to tell the judge, yes, they did have a failure to appear, and here was the circumstances of that, because I've talked to my client, I've talked to my client's caseworker, I've called up their family, and their family is here now in the court to show you, Your Honor, that there is a support network here for this person, right? All of those things are really, really important to getting better results at bond hearings. So we'd want to start that process of reaching out to people earlier. In that first interview, if then is the point we would detect a conflict, you would have to step off and alert the panel attorney who would be taking the cases for that. As far as the question then of how we interact with the district court around this, the presentation with all the steps that I just laid out was made to the judges during the indigent defense work group. We also met with the judges outside of that, or at least some of the judges, to sort of say, here's the logistics that we are envisioning around this in the way that this is going to be best. Obviously, that's an ongoing conversation. It may be that we find out that something's impractical, but we did have the opportunity to go do a walkthrough of the jail with Sheriff Armbrister and talk through where might we be able to meet with clients ahead of first appearances if we were going to do that. And so that's the nature of the conversation around how we would screen for conflicts, when we would screen for conflicts, and then what the process would be for once they're detected. Now, obviously, the judges are always going to have a role in determining if there is a conflict, but the fact that defenders have access to that data and collect it in a way that's different than the rest of the court collects it means that oftentimes we're going to be the first ones to know if there is a conflict that would require us to get off. Does that answer your question?
It does, thank you. I think one clarifying point, so in the instance where, so if you're doing that morning screening and trying to establish it before first appearances, and flag anyone who you automatically know is a conflict. Is that something you envision that you would be in contact with the courts about ahead of time? Because at first appearance is where appointments would be typically made.
Yeah, I mean, that would be the ideal, right? And this is the advantage of having one institutional defender doing these every single day, is you get really good at the process of doing all of this. And everyone in the system gets good at doing the process of all of this together. And so, yeah, again, at the federal level, and this is also something that BIDS does pretty regularly. And we can also borrow from what BIDS does, but at the federal level, this is essentially the process they do. The only difference being that they require their panel attorneys to also meet with someone ahead of first appearances, or at least as close to that is practical. That's going to be part of the evolution of this system. Does that answer your question?
Yep, thanks. Okay, so just one last question. I think it should be quick because I made sure to review. I had in my notes from the budget hearing process earlier this year that I was looking back on, and had some notes about a social worker position, which is not a part of the proposal anymore. Like, I did not see that, and just clarifying that my notes didn't come out of nowhere. Was that something you had originally envisioned and then changed in the proposal?
That is, and this is something that we can confirm with staff. As the discussions, as we had more discussions with service providers and with other stakeholders, there was a concern that we could be duplicative of other actors in the system. The question was raised, is this really the best place that Douglas County can hire and place a social worker? And in the spirit of accommodation, we said, if a social worker is a bridge too far on integrating into this model at this time, we can table that, use the client advocate, right, to do that work. And there are also, frankly, there is some discussion within public defense is the best way to use social workers. How does it interact with mandated reporting? There's a lot of questions around social workers. So I have worked in offices that use social workers really, really effectively, especially as part of sentencing mitigation and for a whole bunch of other stuff. But from the first time that we had ever sort of come up with this idea to when we eventually submitted our budget, we removed the social worker position. So no, you're not missing anything.
Thanks for clarifying the evolution of it. I tried to backtrack through my notes in the recent days and just wanted to have a clear record of that. So I don't have any other questions.
Just a quick follow-up to one of Commissioner Reed's questions. She covered one of mine. One more. Have you done, or is there any modeling around, you took us through the sort of how the conflicts would happen.
Mm-hmm.
And I would think initially there wouldn't be a lot of conflicts, but down the road, there will be more and more conflicts. Have you looked at other communities? Are there models for what, because there will still be a defense panel for those, there'll still be a conflicts panel. What we might need to anticipate as a cost going forward in year 2 or in year 3,
Mm-hmm.
or as those conflicts sort of pile up?
That's an extremely good question. And you're right, probably for a lot of the first year, we're going to not very many conflicts at all. And they do tend to pile up. We have, again, BIDS is kind of the best representative, although the conflicts in felonies look a little bit different, right? Where you have something like a robbery that might have co-defendants, usually don't have co-defendants on a DUI, for instance, or driving while suspended. So the volume overall of conflicts is probably going to be lower than it is at the felony level. And I think we have the benefit here of having Heather Cessna and others from BIDS who can give us the numbers from them on the volume of conflicts. But based on on what we've seen in other offices, based on what we see of bids, something in the range of 10 to 15%. For misdemeanors seems to be the most likely. You also have to remember that the conflicts can also be managed in a number of different ways. So for instance, Kansas Legal Services deals with this a lot. There's more stringent versions of conflict, which is where it's imputed strictly to the individual attorney. We would be at a disadvantage there because we're working so often as a team. And so our numbers might be a little bit higher as a result of, it would truly be a conflict imputed to the firm because of that team-based approach. But so the short answer is that 10 to 15%, cannot imagine more than 20. But that's something that we're going to have to study, but probably would not be as significant a concern in the first months and years.
Could I ask a follow-up to that? You brought up Heather Cessna and bids, and as you know, for some of the kind of context locally, we are hoping that the legislature will fund a bids office for Douglas County. One of the concerns that I have heard from community members is that this might be replicating services because Kansas is weird and we do felonies and misdemeanors separately from a budgetary process. How do you see KHD working with bids, particularly in the long term, if the felony office comes to pass?
This is a great question. There is something very exciting happening with public defense all over Kansas. BIDS has gotten funding recently to compensate its attorneys and hire new ones and hire a training director that hasn't existed in the last 20 years. There is obviously the possibility of other communities getting felony defenders offices. And so that's something we're very excited about, very eager to partner with in the short term and in the long term. In the short term, I think our partnership looks like wanting to collaborate as closely on training as possible. So, again, when we are doing our trainings, I've been on the phone with the BIDS training director, who is also here tonight, about, sharing our access to the trainers that we're communicating with to make sure that somebody trains up KHD, we can get them to do a BIDS training, collaborating on that, right? So there's very short-term collaboration that I think would happen within the first year. Then the question is, where do we go when there is a felony office in Douglas County? And there's a number of different options there. So the Kansas statute specifically allows counties to contract with BIDS to do misdemeanors in the same way that the county might contract with Kansas Holistic Defenders. If there was a felony office, one option that we are seriously considering is rolling Kansas Holistic Defenders into BIDS, essentially gifting the organization and having this be the misdemeanor part of a larger BIDS felony office. That has a lot of advantages to it. And again, because we are a nonprofit and because we have just a mission of wanting to have the best defense possible and to eliminate mass incarceration and to spread the zealous and holistic model of public defense, it's not a problem for us to, in some ways, plan for our own obsolescence in that way. But that's one option, would be a sort of like integration of the offices. Another option could be having essentially a conflicts office, the way that BIDS having KHD be a conflicts office, the way that there's a conflicts office in Shawnee County. There's some disadvantages to that. In that we might not be a very good conflicts office because the number of people we'd already be representing within the community. That's a second option. And then third option would just be to remain separate. I understand that it is a priority of the county to avoid a duplication. And again, this is something that's in our written materials. We are committed to avoiding that scenario however we can, and are open to all the options that are on the table for how we might interact with a bids felony office. I don't think this needs to be said, but I want it to be clear that Kansas Holistic Defenders supports a bids felony office here and in every community of our size. Did that answer your question, Commissioner?
Well, thank you very much. We will ask Douglas County Defense Services to come forward for questions.
Sarah, do I need to touch anything? Okay. All right, as you know, I'm Mike Clark. I'm one of the attorneys associated with Douglas County Defense Services, and I'm the one who submitted the proposal.
Yes, thank you for being with us today, Mr. Clark. Based on my own personal experiences from when you were here with us for a work session and hearing from community members, as well as some of the items included and items not included in your proposal, I do have some concerns with how Douglas County Defense Services would handle issues of equity, particularly racial equity. There was only a single sentence for the two questions that was copied and pasted for the two questions about equity. Could you tell us a bit about how you consider equity in your legal practice and how you would see that as a part of DCDS's work?
Well, my first response to that is, as a public defense organization, our primary responsibility is to each individual client, right? I don't get to pick my client's race, gender, sexual orientation, any of that. I accept the client as they are, and my duty is to that particular client, right? So in terms of what we do, we would do the same thing that you heard from Mr. Natali. There's no difference in what we would do. And in fact, our board or the attorneys associated with us, we have female members, we have Black members, we have a person of Lebanese descent. So we have quite a bit of diversity within our organization itself. So, you know, in terms of what, I think the questions on the form that we used asked, what have we done in the past? Well, we're a brand new organization. So there was no answer to that because we don't have a history as a collective group. Now, individually, we do have a history, but as a group, we don't.
Because my concern is that one of the things that we've been working on as a community for a long time, well in advance of the discussion around indigent defense, part of the work of the CJCC, part of why we funded a law enforcement stop study, is because of the systemic racism that's currently a part of the criminal legal system, discussions that have been happening nationally and locally. So the response about how to handle individual clients, I think, is admirable and important, but how do you deal with issues of systemic racism that affects all aspects of the criminal legal system?
Well, I know from my own personal experience, and for example, participating in the incarceration alternatives work group with Mike Brower and that group, that we were all very familiar with the statistics that were compiled through the CJCC. And, you know, we're all very interested in understanding why those disparities exist. I don't think anybody came to any particular conclusions, but we're all very aware of that. And I know locally, statewide, and nationally, there's a lot of emphasis on understanding implicit bias, right? And those are things that we work on constantly, trying to understand that. So I don't think I could single us out as doing anything unique. I think across the board, criminal defense attorneys in this country are focused on those issues.
Hi, Mike. It's Commissioner Reed here. I think I'd like to give you the chance to talk about the $400 fee that is discussed in the proposal. In conversations with some of the attorneys as part of DCDS, I think that what is written in there not convey perhaps what the intent was. So I would like you to explain what that's about and procedurally, how you envision that functioning.
Sure, and I will state that I've secondhand received some correspondence from Mr. Natale that criticized our proposal for that same reason. And I think there's just a general misunderstanding of the law that's applicable to reimbursement of attorney's fees. So KSA, I'm sorry, it's KSA 216604D specifically provides the court shall, not may, shall order the defendant to reimburse the county general fund for all or part of the expenditures by the county to provide counsel and other defense services to the defendant. So the $400 that I included was a recommendation. It actually wasn't part of our proposal. It was just an ancillary recommendation to the county of how to handle reimbursement of fees when we're no longer, like as individual attorneys right now, what happens is we keep track of our time and we submit vouchers to the court. And the court, in each case in which a misdemeanor defendant is sentenced, must make an individualized determination of that defendant's ability to reimburse the county for those fees. But I think in either model, since we're not billing for individual clients, there has to be another way to calculate what those fees might be that would be reimbursed to the county. And so basically I picked $400 because it was less than half of what the anticipated cost would be for each individual case if you just gave a flat fee, right? So $400 is less than I think anybody in private practice would accept a misdemeanor case for. And so it was basically just a cap. Now that still goes before the judge in each individual case. And again, the judge makes a determination whether or not the defendant would be required to pay the $400 back, $200 back, or nothing back. Again, it's an individual determination. So that $400 has nothing to do with us in terms of getting money back to the attorneys within our group. It was just a recommendation, just like let's set a ceiling, because you don't want it to be so burdensome to people that it sets them back, right? Often we're making arguments to the court that, look, yes, you could assign attorney's fees, but they also have evaluations that they need to get, right? And we think those resources would be better spent by our clients getting those evaluations rather than reimbursing the county for the cost. But those are arguments that we have to make on an individual basis based on the unique circumstances of our clients. Because again, the statute says the court has to order reimbursement of those fees unless they're not able to afford to pay those, and that's on an individual basis. Does that make sense?
I mean, it makes some sense, and I'm familiar with the court process to know that those fees may be assessed at the disposition of a case after sentencing, at sentencing, and that oftentimes, I would say more often than not, they are waived because somebody who is appointed indigent defense has remained indigent, or their financial circumstances have not improved enough to make it so that they are able to pay those fees. So they are often waived. What I think I hear you saying is that, so you're talking about a cap, no more than $400 that somebody might have to pay if the judge determined this defendant should pay some sort of fees as based on information that's collected at the time of sentencing, right? So you're suggesting that this is a cap rather than the court determining that number on it would still be a number determined on a per case basis, but no more than 400. And I guess the part that I'm still a little unclear about is, the way that it reads on paper is that there's a $400 fee assessed to somebody in order to have receive indigent services defense through DCDS. And so I think that that's what a lot of people's questions and concerns have been raised, because that is how it reads, and it doesn't really explain that and be clear with me, please, like people are not paying $400 upfront upon being appointed an attorney. Is that the suggestion that you were making? Or is it purely that it would be a cap at the end of the case, that the court could not go beyond $400?
Yeah, there's no advance fee at all. The only advance fee that I'm aware of in indigent defense services right now is through bids, right? There's supposed to be $100 application fee that, again, judges often waive, but not always. And that's, again, something, you know, that's not part of our proposal, right? I mean, personally, I could care less whether or not the county recovers funds, right? I'm a former military public defender, and we provided free legal services to anyone, regardless of ability to pay. But again, you know, working within the statutory framework that exists, it calls for the court to impose or assess fees against a defendant. It was only a suggestion. Again, it was not part of our contract proposal, but again, it was just something for the county, really the court, to consider. I don't know whose responsibility it is to determine the level, the threshold or the limit for reimbursement of those costs. It could be the county commission, it could be the court. It's certainly not our place.
Commissioner Reed, can I follow up a little bit? So, Mike, thank you for being here. Does Douglas County charge for house arrest? Do you know?
I believe that, well, in municipal court, for example, clients will fill out a financial affidavit, and if they financially qualify for house arrest, then there's no charge to the defendant. If they don't financially qualify, then there are other providers that they can use, but they have to pay that cost themselves.
Does Douglas County charge for drug court?
Does Douglas County
Charge for our community members who go to drug court? Do we charge for drug court? Do we charge a fee for drug court?
I would have to defer to Mr. Glover, because I'm actually not one of the attorneys that handles the drug court stuff.
Yeah. So I could be wrong, and I'll say that, but I don't think I think we've worked really hard as a county to make sure that we're covering those fees, because we recognize how that implicates, or how it makes it more difficult for those who are in the system. And I guess I appreciate you answering the question. I appreciate Commissioner Reed asking it. It was on my list as well. But it was surprising to me to see that in there, based on the work that we've been doing as a county, thinking about fees and how fees impact people in the justice system. So I just share that with you. It doesn't need a response, but I just share that with you, that was curious to me as well.
Well, again, I think there's a somewhat of a misunderstanding that's not within our control within, and again, I just read you the statute, right? So, but in line with what you're asking, you know, another recommendation that I made that wasn't part of our proposal, but was a recommendation to the county, was to provide funding for drug and alcohol and batterer intervention evaluations, right? Because that's a situation where constantly we have clients who are hung up in the system longer than necessary because they can't get the required evaluations. So anytime a defendant is sentenced, for example, for a misdemeanor DUI, before they can be sentenced, there is required a drug and alcohol evaluation. And the cost of that evaluation is set by statute, because part of that money, I believe, goes back to the state, right? So those evaluators charge a minimum of $150. And that's often very burdensome from our clients. And so if the county were to basically pay for those evaluations, it could then potentially tax that as costs, and then let the judge make the determination of whether or not the defendant is financially able to reimburse the county for that cost. But again, I wholeheartedly agree. Anything that we can do to remove barriers from people remaining in the criminal justice system is what we want to do. You're not going to get any argument about that from any of us.
Mr. Clark, I recognize that what the statute says and that it's not up to the county commission or either of these proposals to set a fee. It's up to judges to determine if an individual client can pay. But I think one of the big concerns that I saw is that even with that cap, the suggestion from your proposal is $400, which significantly exceeds what many or any indigent clients can actually pay. So I think that the real concern is that that is where the proposal started. And so the why 400, where was that coming from? I recognize it is less than what private attorneys would charge to handle these cases, but it's still setting a benchmark from your proposal that is much higher than what many of the clients and what the expectations, as Commissioner Kelly pointed out, what the expectations of our county are when it comes to charging folks going through the criminal legal system here.
I understand. And, you know, BIDS, for example, has a chart. If you go to the BIDS website, has a chart that lists what defendants receiving felony indigent defense can be expected to reimburse the state. And that's a starting point, again, because the court, the judge can still reduce that or eliminate that if they find, again, making a particularized determination in that case that those fees should be waived. But again, I perfectly happy if the county commission thinks that they have the authority to do away with the fees, that would be great.
Well, there was just another aspect of funding in the proposal that I did have a question about. We have a lot of folks in our community who do a lot of board service. I am one of those. I know that our fellow commissioners do that as well. And I was a bit surprised to see that there's $12,000 in compensation for board members as part of this proposal. I recognize that there are incredibly esteemed board members who are a part of this, but the idea that this was written into the original proposal, I found kind of surprising. Why do you think that that's a necessary part of the county to pay for board service?
Again, I would point out that that actually wasn't part of our proposal. That was just a recommendation for the county to consider. And the reason for that is, and again, I would point you to look back at the proposal. It very specifically says additional recommendations for the county to consider. But the individuals who would have agreed to serve on our board honestly have said they don't want compensation, but I put that in there because indigent defense services is a responsibility of the county to pay for that. And those board members would be doing services, spending their time and energy on behalf of the county. Now, the reason we wouldn't pay that to them is because that would seem to be a conflict of interest, right? If they're supervising our general performance, then we shouldn't be giving them money to do that. So that's why that was written in there in that fashion. But again, the current members, which includes retired Judge Martin, retired disciplinary administrator Stan Hazlitt, have both said they don't want any compensation. So it may be a moot issue. But I want to make it clear that they wouldn't be receiving any compensation from us because that would seem to be a conflict.
I do recognize the professional credentials of the potential board members. I was also a bit concerned that you don't have any folks with lived experience or community members who would be providing feedback, or anyone with a different racial or ethnic background. And so what kind of outreach would you do for folks with lived experience with the criminal legal system, as well as having any sort of diversity when it comes to your board?
Well, one, I would again point out that we have quite a bit of diversity within our group itself. The other issue, we did recently add another potential board member who's not an attorney. And I wrestled with that because really, in terms of supervision or oversight of attorneys, we can't have non-attorneys doing that, right? For example, private law firms, you can't have an owner a member, if it's an LLC or a corporation, who's not an attorney, because the professional rules don't allow for that. Statutorily, ethically, it's not permissible. So what I would say, though, I think in broader terms is that the work that we do every day is important to equity, right? I mean, Mr. Natale got up here and I agreed with what he said. You know, misdemeanors are very important, right? But frankly, that's the most important part of these proposals is the defense of the person. All these ancillary things are important, but and honestly, there's a lot of overlap in what was discussed earlier. But again, the most important thing is the representation of the individual in the criminal case.
So I want to offer you the same question that was asked to KHD regarding working with bids. I appreciate Commissioner Portillo walking us through, and I think when we very first started talking about this, we didn't know that bids, if they receive funding, would be here. And so now as we see, I think we all hope that they'll get that funding and that they will all be here. We're concerned, I have a concern about having multiple public defenders and how that would best serve our community. Can you tell me what discussions you've had with bids and what would be, I mean, the plan you gave us was for 5 years. They probably would be here in less than 5 years. What your strategy, how you've had conversations with bids, and if bids did come in, how you would integrate your services with theirs?
Well, currently, I think all the attorneys who are part of our proposal are currently on the felony appointment list as well. So we already work with bids. So to the extent, you know, for example, Mr. Natale talked about the fact of being appointed in cases in misdemeanors, and then if they pick up a felony, you know, they'd like to be able to jump on that case as well. Well, that already happens now with us, right? In fact, very frequently, you know, people come back into the system for whatever reason, right? And they've been represented by an attorney before, and almost always the court will reappoint that person to represent them again. So there's a continuation of that relationship with that individual. So you're not starting from scratch. And we would do the same thing. I mean, I don't see any potential for conflict or not working well with bids because we already do that. So, I mean, we're familiar with the bid system and how it works. You know, I've been practicing here in Douglas County for 20 years working with bids. So, and I think, you know, the other attorneys in our group have the same experience.
Mr. Clark, I'm going to just follow up on Commissioner Kelly's question, because I think part of it was the shift in our relationship with bids as a community. So our hopeful goal is that we'll have an institutional bids office once the legislature funds it. And so there will be a shift in the relationship of panel attorneys with bids and a shift in how our community handles indigent defense. Have there been any conversations between you or other attorneys as part of your proposal with bids about how you might integrate, particularly since you gave us a proposal for 5 years and hopefully we'll have funding from the state for a bids office to open well before that?
Well, there have been no discussions that I'm aware of between myself and anyone else associated with our proposal and bids. And while obviously we're aware that bids was looking at establishing a felony defense office here, the idea that bids might take up misdemeanor defense is not something that I was aware of.
So in the Kansas Holistic Defenders proposal, one of the things they do is they have some outside funding. I didn't see that in your proposal. Is that not something that your group is working towards? Any outside funding? It's all coming from the county. Am I understanding that correctly?
Certainly initially that would be the expectation. You know, we have not established the entity yet. In fact, one of the things when I submitted the proposal and I spoke with Ms. Polinsky, and she asked, are you going to be a nonprofit or what's the nature of your organization? And my response was, we'll do whatever works best for the county, right? Because the goal is not to generate passive income for any of us through the existence of Douglas County Defense Services. Basically, the only revenues that would be retained by that organization, whether it be nonprofit or otherwise, would simply go to pay for staff and overhead, right? But if we establish that we're a nonprofit, for example, then I think for sure, I would expect the county would assist us in identifying funding sources, grants that we might apply for. I think, my limited experience, Commissioner Portillo, you probably know because of your association with KU, how difficult it is to apply for grants, and that's kind of a specialized skill. So we might need some assistance in doing that, but there certainly would be no reservation by us to do that. I mean, that's a no-brainer.
Noel, to piggyback off that question a little bit, I guess maybe it's in conjunction with another question I have written down and that I had also posed to KHD. So if you are a nonprofit in particular, how do you envision all of the attorneys on that list have private practices, are in private practice, many of which your own individual offices? How do you envision what the continuation of those private practices would look like? I'm also aware of that some of you have contracts with the municipal court, which is a decent caseload, I would imagine. Also, in addition to the other panels. So can you talk to me a little bit about how the 7 of you have discussed what that caseload looks like, and how if you were to be awarded county funds for the proposal that you submitted, you would manage caseloads, and also the same question that I had asked them about procedurally assessing for and addressing conflicts as they arise.
Sure. So within our proposal, I think I listed out kind of the standards. I think Mr. Natale referred to them as ABA standards. I think they've been adopted by a number of organizations in terms of, the upper limit in terms of felonies and misdemeanors and other cases. And in fact, I know Ms. Cessna, had a report to the legislature about Indigent Defense Services, and she referenced those standards as well. So it would be our expectation to maintain caseloads below those levels as well. And that's why we have 7 attorneys at this point. Now, we may need to retain more attorneys if the caseload goes up, but given our historical numbers, I think, on average, we used to be about 600 misdemeanors a year. I think Mr. Natale noted this last year that has gone down, or last year and a half, probably because of COVID, but also because we've had a change of administration in the district attorney's office. But within our proposal, I guess we have the built-in flexibility to expand or contract as necessary, because again, Douglas County Defense Services is not employing attorneys, right? We're contracting with attorneys, and that provides us with additional flexibility. The other thing within our proposal, I think I put in there, was that we would use probably Clio, which is a practice management software, centralized. So each attorney's caseload would be able to be monitored to some extent just by referring to the software. But each month, we would expect each attorney to make a report to Douglas County Defense Services to make sure that we're not taking on too many cases, right? Because while I practice almost exclusively criminal defense, right? Ms. Butler, she does some domestic work. Same thing with Ms. Downing, right? So those would have to be factored in to make sure that that none of the attorneys are overburdened. And there may be times when we have felony cases that are so big, right? You know, I was on the Mass Street case, right? That took a lot of time. So even though that's only one case, that still may be too much. And we say, look, I need to take a break for a little while, and other people go into that rotation, taking on new cases until this clears out a little bit. And that's one of the things that our policy board would monitor for us. That's the expectation. So Judge Martin, Stan Hazlitt, you know, they would stay abreast of what's happening in our practices, because again, they can't micromanage an individual case. So they have to look more at the big picture, because obviously it's up to a judge in each individual case to monitor the performance of all the attorneys involved, prosecutors, defense attorneys, and everybody else. And so in terms of, I'm sorry, so dealing with the conflicts, you know, just like Mr. Natali pointed out, you know, there's software that you use to monitor conflicts. And we would have to combine our lists so that, you know, our support staff person would be anticipated to be the first line of identifying, you know, if there's a named victim, has Mike Clark represented that victim in the past, in which case I probably can't represent the defendant in that case if I've represented the defendant, right? So we're going to pass that on to another attorney on our list. And again, that's the advantage of not having attorneys under one firm, but instead an umbrella of attorneys who have contracted in, because it avoids having conflicts where we would have to refer out to the panel. We'd have much more capability to handle the full complement of cases that would be assigned.
Could I ask a follow-up to that? One of the things that we spent a lot of time talking about in the Indigent Defense Work Group, and Mr. Glover is well aware of this, being a part of that group, is some of the goals that we have when it comes to institutional defense is that there will be attorneys who do work in the same office and do work together. So I think the focus on having contract attorneys gives me a bit of pause, because if the goal is that your board has oversight of caseload and how things are handled, that means that there isn't necessarily that kind of day-to-day management. One of the positives of having an institutional office, when we look at the research around institutional defense, is that you have kind of that informal mentorship that happens in offices, that there's an organizational aspect, there's an actual institution built up around the office. So what I see in this proposal is kind of a group of independent contractors coming together under an umbrella. And really, that doesn't address some of the real positives that you get from an institutional office. So how would you then make sure that you have that kind of informal mentorship, the management piece, making sure that there isn't, I mean, you have folks who have retired from really rigorous careers. How are they going to have that day-to-day oversight of the office as board members rather than as managers?
Sure. Well, my initial response would be these 7 attorneys were selected in part because we already collaborate quite a bit and we work well together. You know, earlier this week, I think Ms. Butler sent out a text to us asking if any of us had a particular motion, right? And so we responded to that. So we do that stuff all the time. We're a fairly close-knit group, but not exclusive. I mean, we've all, especially this past year, we've all worked to improve indigent defense, quite frankly, defense services in general in Douglas County through CLEs. You know, Mr. Glover presented on jury selection. His wife is a very reputable expert on jury selection. So he and his wife gave that presentation. Ms. Downing gave a presentation on ethics. You know, we had presentations from Shannon Oury, who's the director of Douglas County, Lawrence Douglas County Housing Authority, to tell us about the resources that might be available to assist our clients. We had Stephanie Davis from the Veterans Administration come in and talk to us about services that might be available to veterans who are our clients. And we had Car Wu, Artists Helping the Homeless come in to talk about the programs and the services that he offers, because I do a lot of referral to him. And we've had Bert Nash, we've had DECA, we've had RADAC, all those people come in. So we're constantly working within our small legal community as it exists now to improve the services. We're already doing that. And I would certainly expect that to continue and probably increase to a certain extent, if we get this contract.
Well, and I guess you kind of mentioned that internal collaboration. One of the goals, again, with an institutional office is that there can also be a point of contact for external collaboration. So providing resources to panel attorneys who are not part of your inner circle. How do you plan on actually kind of collaborating around training for folks outside of your office, or I guess offices, to make sure that we have that community level of support?
Well, I guess that what I was saying is we already do that. So I personally set up all the CLEs that we've done over the last year and a half that I just talked about. Hannah Sue, who's sitting here, who's incorporated in our proposal because she's an immigration attorney. She happens to be bilingual as well, Spanish speaking. So she gave a presentation, not just to us 7, but for the entire defense bar. And I would anticipate that continuing, because quite frankly, I love doing CLEs, right? It's energizing for me. I learn more when I prepare to do that presentation. You probably know from your own teaching experience, when you prepare to give presentations to other folks, you end up learning more yourself. So I fully would anticipate we would continue to do that.
Thank you. Can we go back to that kind of subject of learning? Because I do want to return to this question of kind of a for-profit or nonprofit. And you mentioned that you'd be open to doing whatever makes sense for the county. Throughout our budgeting process this summer, whenever we had proposals from community partners, one of the big things that we discussed is their ability to leverage county funds for other external funds. And I really appreciate your recognition that grant work is very specialized work and it can take a while to learn. And I think that the county always wants to be a good partner in some of that. But what has your organization, or you individually or other attorneys individually, done to ensure that you have the ability or will have the ability to use county funds to leverage other sources, to think about that grant writing, to think about that role of making sure that you have the resources that you need, not just from the county, but from other spaces?
Yeah, we have not engaged in that yet, because honestly, we don't exist as an organization yet, so we couldn't do that. But I do recognize, from my own personal experience, working with Habitat, right? They would always be applying for stuff, and that's where I first kind of got my first glimpse at how difficult grant writing is and stuff like that. So I don't mean to minimize in any way, shape, or form how difficult that may be, but I have no doubt that we would be on board with doing what we can. And maybe Mr. Natali can help us in that regard, make some suggestions, because it sounds like he's versed in that.
I have one more question to suss out about the the structure, and I hear you that you're not fully formed, perhaps, or as 7 sort of independent contractors, as it seems to be generally described right now, I think in the proposal. Help me understand more how that 550,000 that's requested, or maybe it's 525, but thank you, 525 that's requested would be dispersed amongst you. How? Because in the KHD proposal, it's per salary basis. Historically, the panel system is relying on vouchers, and that those billing sort of statement, or I don't know if you'd call them billing statements, but statements that summarize the amount of time spent on the cases. So help me understand what the money would look like going to the 7 attorneys plus the support staff that you've incorporated without salaries being at play, and in mind with, I guess, that goes along with the question and it's part of the conversation earlier about how you all would be weighing caseload and requirements that each of you might have based on your private practices outside of this contract.
So the easy part to answer on that is the salary, for example, for the support staff. And again, I plagiarized Ms. Cessna's report that she gave to the legislature last September because she had estimates in there in terms of how much it costs for an investigator, paralegal, administrative assistant. And, her numbers included overhead and benefits and things of that nature. So that's where those numbers came from. And then obviously there would be a certain level of money that would have to be spent on like computers and phone system and the software, the Clio, for example, that we talked about. So those are the hard costs that would be known, from the get-go, when and if we establish this, right? The contract proposal that I submitted was based on, and I always forget the acronym, so I'll just refer to my notes. So I used a model contract from the that's published by the Public Defense Service, by the National Legal Aid and Defender Association. And within that contract, the model contract, it seemed to provide for fluctuations in the number of cases, and that would correspond to the budget. So within the proposal, which I understand, the county may, if a proposal is accepted, they may draft a completely new contract for us. But the idea is to have flexibility in terms of the budget, so that if the number of cases goes down significantly, then the amount of money that we received can go down the next year, right? So because, if the number of cases drops by 25%, then we wouldn't expect the county to be paying us at that same level. So, that initial bid number, if you will, was a starting point, again, based upon historical numbers in terms of how many misdemeanors are charged. So whatever the expectation is that there's just going to be kind of a monthly payment to attorneys, depending on the number of cases that they take on per month. Because the expectation is, for example, that one attorney at least would appear for every first appearance, right? Typically that's at 3 o'clock with Judge George. And so, in the past, honestly, I've gone to the court in the past and said, is there a way that we can get appointments earlier? Because unlike Mr. Natalia, I was on the CJA panel for 15 years, approximately. So I know how the appointments work there, and you do get a whole lot of advance notice, and you do get to meet with the defendants ahead of time. That's not been our ability, but we would like it to be, and that's our expectation with this. With the rotation of 7 attorneys, it wouldn't be the same attorney every Wednesday, but it would be a rotation basis. But again, if you get too busy, you tell the other attorneys, look, I need to opt out for this week, and just slide the next person in. So the number of cases handled by a particular attorney would likely dictate what their compensation is for that particular month. If that makes sense.
May I follow up? Mr. Clark, you brought up data from bids, and I think that some of the data that bids shared with us when it comes to cost in Douglas County, I found really fascinating that Douglas County has some of the most expensive per case costs in the state. We have the most expensive per case costs in the state. And that when we look, it's having an institutional defender's office in our state results in cheaper per case costs. And so one of the things that, again, I see as a potential benefit of an institutional office is that with salaried attorneys, you have the full focus of the attorneys, but you also have the potential to really try to focus on handling those cases efficiently without having to think about how many hours are being billed and that sort of thing. There's both the kind of dividing time and that fluctuating cost that's more difficult for the county to budget for, but also the limited data that we have on indigent defense in our community shows that panel attorneys tend to be more expensive than salaried attorneys. So why should we continue with a contracting model?
Well, one, I guess I'd like to address the cost of felony indigent defense services in Douglas County. I was on Motel 6 case, murder case there. I was on Mass Street. I handled the case where the man was murdered and then that house was burned, right? So the last few years prior to COVID was really rough on Douglas County. We had an influx of high-level felonies that I had not experienced here in Douglas County. So I think you have to take those numbers maybe with a little bit of a grain of salt and understand that the cases that we were experiencing necessitated that. The other thing is it also probably reflects the quality of services that I think defendants were getting out of Douglas County, and that was probably acknowledged by the judges, right? The judges still monitor and approve our vouchers before they're sent to bids. So they have the ability to cut vouchers if they think that the billing has been excessive, and they have the ability to approve vouchers in excess of the caps when the case warranted that. I understand when you look at those numbers just objectively without knowing the specific cases, it may be alarming, but I think maybe there's more to that story than first meets the eye. Addressing your specific question though, our model, I would say, is more predictable of the county costs than the holistic defenders is, because our proposal, I believe, eliminates most, maybe not all, but most conflicts, right? So you're paying us whatever you pay us, that's probably going to be the vast majority of what you're going to end up spending on indigent misdemeanor defense services in Douglas County. When you only have 3 attorneys working in the same office, the conflicts, as was noted, are going to build up over time, and that's going to mean additional money is going to be needed to pay panel attorneys for the cases that holistic defenders can't handle. And I think we, for the most part, eliminate that problem.
Okay, there are no other questions. We will begin to open this up for public comment. Sarah, I did see that we had a sign-up sheet. I don't know if it got circulated.
I had not circulated it yet, but I can certainly do so. Judge Martin, and if you're not at the microphone, you're not on the record, so.
Can I just give you a specific answer to a question you asked that Mr. Clark wasn't able to answer?
Sure.
Concerning grants, Alice Lieberman, a retired professor of social welfare, has joined the board. And as an academician, you know that your research is funded by grants. And Dr. Lieberman has spent her career writing grants for funding her research at the university. And on our board, she will assist with grant writing.
Dr. Lieberman has an incredible career. There was no indication that she would be in any part doing grant writing. And is she here today to talk about any grant writing that she's planning on doing as part of this project?
She's out of town.
Okay, thank you.
Thank you for letting me address that.
I do just want to remind folks online, as we're having people sign up for public comment here, that we will take public comment from everyone present in the courthouse before taking public comment from folks online. If you are online, please use the raise your hand function on Zoom and we will get to you for public comment. Since we have been going for 2 hours, we're going to take a quick 5-minute break while folks are signing up, and we will come back at 7:30. I taught summer camp as well as universities. Okay, just a quick reminder, all public comment is limited to 3 minutes. Sarah has beautiful yellow paper that she will hold up for you, indicating when your time is up. When she holds up the stop sign, please stop. We do ask that everyone share their name and address for the minutes when making public comment. Again, we will take public comment from everyone here in person and then go to online. If you would like to make comment via Zoom, please use the raise your hand function on Zoom. We will start with Blake Glover.
Hear me okay? All right, microphones. Blake Glover, 608 High Street, Baldwin City, Kansas. I am an attorney. I'm here as part of my role in the Douglas County Defense Services proposal. Just a little bit of background. I have opened my own private practice in Baldwin City, my hometown, back in January of 2014. I'd been at a prosecutor's office in Texas prior to that, but moved back to my hometown, opened up an office, and immediately applied to be on the indigent defense panels for both the misdemeanors and the felonies. I was awarded that opportunity, and since then I have continued to be on those panels representing indigent defendants in Douglas County, and anything from low-level misdemeanors all the way up to murder. In addition to my representation of indigent defendants in Douglas County, I've been on part of a couple of work groups, of course this one on indigent defense. I'm also have been a part of and continue to be a part of the pretrial release work group. That was a collaboration between defense attorneys, myself and Shay Downing, who is another member of our group that was unable to be here tonight, along with the judges, the prosecutor's office, court services, and other stakeholders. I'm proud of our work in that group. And I think it needs to be mentioned because one of the things that was mentioned was meeting with clients before they get out of jail. And our work in that group has virtually eliminated misdemeanor people being held in jail in Douglas County, barring exceptional circumstances. And if we're just talking about district court cases, I don't know about municipal, but just district court cases. This is the work that we have done and the 7 members of our group have done and continue to do in our everyday careers. As I sat and listened to a lot of the questions, and they were good questions, but I feel like we're missing one very important part of all of this. There were no questions asked about the qualifications, okay? The 7 attorneys that are a part of our proposal are all attorneys that have invested in this community and invested in indigent defense. We are all attorneys that are not only qualified for the misdemeanors, but the highest level felonies in our county. And we may not use the word holistic, but every single day in our practices, we connect with providers. We have relationships with DECA, with all the various services. The only reason that people are going to be appointed an attorney in Douglas County is if they are charged with a crime. Qualifications matter. And I'd ask that you, what I'm asking you to do is table this decision. The work group identified further data that needed to be fleshed out. Table this decision. Allow that data to be collected, and then the commission would be able to make a more informed decision. Thank you for letting me speak.
We'll move to Hadam Shaheen.
Commissioners, in Ms. Portillo, Commissioner Portillo's Hadam Shaheen. Commissioners, all we wanted was a deadline. But before I start, I'd like to thank Judge Martin, Stan Hazlitt, and the group of attorneys listed on the Douglas County Defense Services. I'm lucky enough to not only work with this fine group of attorneys, but also call them my friends. And I'd like to thank the Douglas County Commissioners for taking the time to seriously consider our proposal. I'd also like to apologize. By my very nature, I'm a criminal defense attorney. I'm aggressive and I have an adversarial tone. I'm a strong voice for clients that have been accused and sometimes wrongfully accused. when statements are made on an open record about Miss Downing, about Mr. Glover, and closed door statements by Commissioner Portillo about Mr. Clark, it makes me aggressive. It makes me have an adversarial tone. But again, I apologize. I'm a defense attorney. I've never run for public office. I'm not seeking a public office. We believe that the proposal before you is not only cost effective because it cuts down on the conflicts of cases, but it provides the most experienced, bench and trial tested attorneys for misdemeanor clients. Plus, we've been working with community partners and our clients here in Douglas County for many years. And all we wanted was a deadline. All we wanted was a chance to put forth a proposal that would equally be considered with that of Mr. Natali. Again, all we wanted was a deadline, an RFP. Since there was no deadline, commissioners, since there was no RFP, why not just call Mr. Natali's proposal exactly what it is, which is a no bid contract? It would have saved us a lot of time in the room. There's a lot of professionals here, a lot of attorneys, some retired judges. Why did it take a whistleblower at a local level to expose the connection between two of the commissioners and Mr. Natali? I questioned why. I didn't care about Mr. Natali's lack of managerial experience or his lack of trial courtroom experience, which was in a resume that was mailed to me anonymously last week, where it exposed the connection between his campaign and yours, Ms. Reed and Ms. Portillo. It also highlighted, and this is the original, which I put in poster, it highlighted his connection as well as his trial experience. Felony jury trials, 0. Felony bench trials, 0. Number of misdemeanor trials, 2. Number of misdemeanor bench trials, 2. I was upset because it took a whistleblower to bring in light the connection between the connection and Mr. Natali, and it didn't have to be this way. I was surprised when Commissioner Portillo said last week that Mr. Natali was on the campaign. The very next day it was exposed in the paper. On Thursday, the paper where it also stated that I worked hard for, okay.
Your time is up. We will move to Josh Harson.
Good evening. My name is Josh Harson. I'm a resident of Lawrence. I live on 19th and Ohio Street. I'm a public health and community health researcher. I focus on gun violence prevention and youth incarceration prevention. I'm here today to speak in support of Kansas Holistic Defenders and the holistic model they propose, as I believe it offers indigent clients the best chance at having a fair day in court, and that it will best serve the health of our community, and also that it will work to address the systemic racial inequities in the judicial system here in Douglas County. A holistic model is one that centers equity and the health and well-being of their client, not just as it pertains to their legal involvement. And it's more than just a word that they use. This means an appreciation of the downstream consequences of involvement in the legal system, rather than considering these to be ancillary or beyond their purview. These consequences impact clients immediately and long-term, meaning that they pay for their offense long after those who are more wealthy have moved on with their lives. For instance, indigent clients are more likely to spend time in jail because they're less likely to have money for bail. This can set off a host of collateral effects for clients. It can threaten their employment, which not only makes it difficult to pay the fines and fees that often come with misdemeanors, which is already a problem for indigent clients. It can also affect a client's ability to maintain housing, put food on the table, and access medical care for themselves and their families. Finding a new job is made more difficult after involvement in the legal system, given the ability of employers in Kansas to discriminate based on applicants' criminal history. All of this compounds, creating cascading penalties that impact the health and livelihood and well-being of our most vulnerable community members and their families for something as simple as a misdemeanor offense. And we know that these sorts of consequences are felt right here in our community. The Center for Community Health and Development at KU, where I'm a researcher, conducted a study in 2019, which assessed barriers to employment for marginalized residents, including people of color and those living in poverty, which are two populations most likely to require indigent offense. Participants in this study reported having criminal background as one of the greatest barriers they face in obtaining good, steady employment. And in the words of one participant, background checks are horrible. Once a background check comes back, even though you've done your job, it still lingers and follows you. No matter how much you change your life, it's still there. You can't get employment. You go back to your criminal behavior because what else are you supposed to do? So not only are these consequences unfair, they also encourage recidivism because individuals are left with no other available recourse. And this is precisely why we need a dedicated public defender's office that operates under a holistic approach. I believe such an approach would serve the public's health and interests well. Thank you.
Thank you. I'm sorry, I cannot read the handwriting after Josh. If you signed up right after Josh and your name starts with an S. Santiago, thank you. You're fine. It is a beautiful looking signature. It's just not.
Not used to these fancy pens. Santiago Vasquez, 3001 West 19th Street. I'm here speaking in support of KHD and wanted to make a few comments on the other proposal that was presented earlier. During the cross-examination, especially, one of the first topics that was brought up was race and issues of systemic racism. I found it problematic that the people defending it kept using over and hyper individualistic ways of expressing how they would address race. As a person of color, I'm very aware of when people are like, we're going to treat you as an individual. You know, we don't worry about all these other things. And that's a huge red flag because that sort of hyper individual approach has been a hindrance to trying to deal with systemic racism that these attorneys should be very aware of. Secondly, and the fact that there was such little attention given in the actual literature about systemic racism shows me that there is a clear lack of importance on their part being placed on those issues. Secondly, on the $400 fee, if the goal is to provide the maximum amount of defense to the people of Douglas County, why would you put that fee in the literature in the first place? And second of all, if you're saying that it's just a cap of $400, why doesn't the language of the proposal clearly state that? It had to be clarified because that's not the language of the proposal. Yeah. Then on the $12,000 being placed to the board, if it was only a suggestion and the people who it would be going to said that they don't want to be paid, why would you put it in there at all? Additionally, they also pointed out that it was a conflict of interest to try to pay them in the first place. I simply do not understand why there's this recurring theme of wanting to add money onto the proposal. Next, I know that someone brought up lived experience. I believe Commissioner Portillo brought up having a representation of people with lived experiences on either of these proposals. And once again, this hyper individual approach was brought up. Real representation goes beyond just having diverse people among your group. There's also has to be this commitment to trying to tackle systems of systemic racism and injustice and providing better services for them. So yeah, once again, that individual approach just isn't great. Then the other issue of outside funding was brought up afterwards. And I think that conversation highlighted how half-baked this other proposal is, because they're basically making it up on the spot. They were creating suggestions the entire time that they were up here because the proposal isn't fully fleshed out on the other side of the aisle. Additionally, in terms of institutionalism and having this, like having KHD be a real institutional board, there's a wealth of literature on their side saying why this is better and also cheaper. And so I think at the end of the day, the question is, why is there any reason to prefer this proposal over what KHD has presented? And I don't think there is. I don't think there's even a real reason for why this counter proposal was brought up in the first place. And I think that it's very dangerous, the kind of language that they've placed in here. Thank you.
Ellie Beck.
Hi, my name is Ellie Beck. I live at 550 Stone Ridge Drive. I'm a first-year law student, and I came to law school with one goal: to help people who may be facing the hardest moments of their lives. Every public defender I know came to the legal profession with the same intention. Not only is that their goal, but public defenders consistently meet it. A Philadelphia study shows that compared to appointed counsel, public defenders reduce their clients' murder conviction rate by 19%, lower the probability that their clients would receive a life sentence by 62%, and reduced overall expected time served in prison by 24%. Under the current appointed system, innocent people go to prison who would not have been convicted if they had had a public defender instead. Kansas Holistic Defenders takes a multifaceted approach to defending their clients, including having advocates and investigators on staff. The National Legal Aid and Defenders Association recommends having at least one full-time investigator for every 3 staff attorneys. Public defenders can work with mental health providers to ensure people get access to the services they need for stability, employ advocates to ensure people succeed on probation and diversion, and make judges aware of reasons to pursue alternatives to incarceration. As county commissioners, I am confident that every single one of you entered into your role with the same goal that I did when I entered into law school, to help people and impact our community. You have the ability to tangibly improve the system of criminal defense in Douglas County for the better. I urge you to choose Kansas Holistic Defenders. Thank you.
Brendan Phillips.
Okay. Okay. So my name is Brendan Phillips. Live at 540 Brentwood, and I've lived in Lawrence my entire life. Figured that might be worth suggesting. So I think a lot of hay was made by the Kansas Defense Services side about qualifications. I think it's important to note that the Kansas Defense Services could design a system, design a proposal similar to the Kansas Holistic Defenders and push their agenda that way. And I think it's important to note that when weighing these two proposals, the significant difference is the design of employment and the design of management in this case. So it's more weighing a system where it's designed for direct provision versus a design of contracting out. And it's important to know that in a system where you're contracting out your services to another entity, you're removing key institutional powers from the government. You're essentially giving more power and more control over to the private entity that you're contracting out to. A similar dynamic you can compare it to is I'm blanking, sorry. The single payer model proposed by, say, Bernie Sanders versus the HSA, the current model we have now, where we essentially contract out and subsidize insurance providers to provide services for everyone in general. That's essentially the model we have now. The problem being if the Douglas County Defense Services comes back in 5 years, in a year, and says, we want a little bit more. We want to be paid. We want to increase the number we're paid. We want to be able to provide more private services. There'll be no institutional stop against that.
Thank you. Heather Cessna.
Hi, I'm Heather Cessna with the Board of Engineer Defense Services, and I just wanted to make a quick clarifying comment because there were some questions from the commissioners about the interaction between the potential felony public defender and misdemeanor services. Certainly, there are allowances for us to be able to contract as the Board of Indigent Defense Services with counties for misdemeanor services. Traditionally, we have not done that. The reason for that has been because we certainly have our work cut out for us, as it were, with felony cases across the state, not just in Douglas County. And while we have certainly had some great successes in the last legislative session with getting some additional funding for our services, we certainly have a lot of work still left to do on felonies. So while I'm not going to preclude that there could be a conversation at some point in the future about misdemeanor and a felony office, I did want to make sure that everybody was on the same page, that that probably is a conversation for a much more future conversation, as opposed to something that is more short-term or something that's in the works right now, just because of where we're at with our felony needs.
Sharon Brett.
Hi, I'm Sharon Brett, 1008 Oak Tree Drive in Lawrence. I'm the legal director of the American Civil Liberties Union of Kansas, and I'm also a board member for the Kansas Holistic Defenders. And I want to focus my comments on why high quality wraparound public defense is necessary in Douglas County and across the state, and how I believe an institutional defender's office will get us there. The ACLU's work focuses on systemic problems in the criminal legal system. Economic injustice, like unaffordable bail and high fines and fees, racial injustice, such as disparities in who is incarcerated and how long they're incarcerated for, issues of due process, including unfair plea bargaining and prosecutorial misconduct. And having a holistic public defense office is a vital step towards identifying and remedying systemic injustice. We want to make sure that localities have robust public defense systems to address issues at the outset and throughout court systems before harm is done and before attorneys at my office need to get involved. Residents of Douglas County and all counties deserve zealous advocates who will leave no stone unturned and who are trained to work as a team to tackle cases from all angles. Misdemeanor defense is of particular importance, and I commend the Commission for taking this obligation seriously. Some people may dismiss misdemeanor charges as less serious and therefore not needing this holistic wraparound model. But as Professor Alexandra Nadapoff describes in her book, Punishment Without Crime, over 80% of the criminal cases in the US are misdemeanors, and punishments for these offenses can literally ruin lives. Convictions can result in impossible to pay fines and fees, jail sentences, lengthy probation terms, and future criminal system involvement. And for that reason, high quality misdemeanor defense is vital. The way that defense is structured and provided will necessarily impact its quality. As Commissioner Portillo mentioned, Governor Kelly's Commission on Racial Equity and Justice recommended that every county with a population over 100,000 people have an institutional public defense office, not a loose organization of private attorneys who divide their time between paid cases and appointed cases, but an actual, quote, organized office, end quote, that, quote, allows training, mentorship, and professional development within the organization, similar to prosecutors' offices in the same jurisdiction. That's what Kansas Holistic Defenders is trying to do. That's what fulfills the mandates of Gideon v. Wainwright. And the Supreme Court has said that the right to counsel is the right to competent, effective counsel. And the Sixth Amendment Center, which is a leading organization on this issue, has said that effective indigent defense systems are those that ensure independence, provide training, and impart supervision for attorneys. So I encourage you to choose the option that meets those goals.
Eileen Berquist.
Eileen Berquist. I live at 1128 Connecticut Street. Commissioners, thank you for the opportunity to provide public comment today. My name is Eileen Berquist, and I'm the Community Engagement Manager at the ACLU of Kansas.
We are a nonpartisan nonprofit organization that works to preserve and strengthen the constitutional liberties of all Kansans. I'm speaking today on a recommendation in the Douglas County Defense Services proposal, specifically the assessment of a $400 fee for indigent defendants. The ACLU is one of many organizations across the country that stands firmly opposed to the imposition of fines and fees in our criminal legal system. We work diligently with partners to make changes at the state and local level that promote an equitable system for all defendants. Though part of a concerning trend across the country, our local governments should not be supplementing their funding through the imposition of legal debt on poor defendants. From a practical perspective, these financial penalties just don't work. Debt-based punishment has an adverse effect on rehabilitation, and there is research to show that these fees are ineffective drivers of revenue. At the same time, a $400 fee is devastating to low-income people. $400 is a chunk of many Douglas County residents' monthly budget. It can mean the difference between paying your rent or your family's groceries or gas for your car to get to work. What may be irritating or difficult for a person of means is devastating to many. This sets up a system of unequal punishment based on socioeconomic status. And if defendants are unable to pay, we run the risk of further criminalizing poverty with the imposition of additional court dates, fees, and wage garnishments. Additionally, there is a very strong argument that the imposition of fines and fees unequally impact people of color. Communities of color are disproportionately impacted by our criminal legal system, from arrest to harsh sentencing and parole terms. In the same way, people of color are disproportionately impacted by the assessment of fines and fees. The nonpartisan Center on Budget and Policy Priorities centers the elimination of criminal justice fees in their recommendations for creating an anti-racist revenue policy. We believe that Douglas County should follow that recommendation. The ACLU of Kansas urges the commissioners to reconsider imposing additional fees on indigent defendants in Douglas County to promote a more just criminal legal system and to help Kansans overcome unnecessary roadblocks to success. Thank you again for the opportunity to present, and I believe I speak for all the ACLU staff. We are happy to answer any questions from the committee at the appropriate time.
Thank you. Jennifer Roth.
Hi, my name is Jennifer Roth, and I live at 644 Mississippi. I've lived in Lawrence for over 30 years, and I have been a public defender with the state of Kansas for over 23. My work that I do now allows me to see cases from all over this state. When I'm not a public defender, my hobby is going to the State House. So I've done a lot of policy work over the last 17 years. And I will admit that I have not paid as close attention to what's been happening in my own town as I should have. And so I thank people like this commission and like the people in Kansas Holistic Defenders and like the people in Mike Clark's group for the work that they have done. I know how hard that can be. But I'm also here to tell you that I'm on the Kansas Holistic Defender Board. I'm one of 5 attorneys that's on that board. And I'm also done with the status quo. While I appreciate that the work that these folks do in the current system, I appreciate that. I know them to have done good, they do good work. I understand all of that. I have also seen over the since February 9th, when Sam gave his first presentation in a public setting to the criminal justice, I can't remember what you call your group. But when he gave that presentation, chock full of science and information and data and research about how an institutional holistic defender can improve outcomes for everyone in our community, the people working in it, the people grounded up by the system, et cetera, I was sold. And I've been on his board ever since. I've seen him work for free during the entire time of this year. I've seen the people on our board work for free, hard on trying to make this a reality in our community. I'm gonna be honest, I've rewrote my things about 5 times, but I'm gonna be honest, I've been I've been chewing on what I heard last Wednesday all week. And let me tell you this, I know about this whistleblower. I figured out, I think, where this came from. But anyway, my point is that it's not some bombshell whistleblower thing, that Sam and other people in this community have been working on these issues, and that in fact, two of the people sitting up there have been working on these issues. That is what our community wants. That is what our community voted for. It is not news. What would be news is if people like Sam and me and others that are in the audience and others in the community weren't holding the commission accountable for what it is we want to see in our community. And what we want to see is a holistic institutional defender that will work in partnership with our existing structure. Thank you.
Thank you. Jolene Anderson.
Hello, Jolene Anderson, 2621 Bishop Street. And I'm also speaking on behalf of Kansas Holistic Defenders. And here's what troubles me. In our county right now, about 75% of the people charged with misdemeanors are indigent. Yet these are the very ones we burden with fines, fees, and driver's license suspensions to encourage payment. In the words of one of the victims, Michael Durham, for minor infractions, my license was suspended for 6 years for $3,000 in fines I could not pay. It was a nightmare. He got his life back when he moved to California. Dave Corliss referred to municipal court as a cash cow because it brings in more money to the general fund than it takes out to support itself. I assume district court may be the same. These and other statistics have led me to believe we don't have a justice system, we have an injustice system that we can fix, and that's why we're here. Now, I read that contract from DCDS. It's a beautiful contract. All the I's are crossed, the T's are dotted. It covers all eventualities and contingencies and shows a thorough understanding of our present system, but it lacks empathy for their clients. The only time indigent people are mentioned is potential fines and fees. The part that shocked me the most was the suggestion that already privileged board members receive a $4,000 per year honorarium as if it were a token or a pittance. An indigent defendant, $4,000 could be a godsend. It could pay off all their fines and remaining fees. These people are deserving of respect and dignity. They are not just cash cows or turnips. KHD understands this. I know Sam Natale, he is brilliant. He understands the law forward and back. He knows how to make our system work for everyone. When justice is done for the least of these, justice is done for us all. The citizens of Douglas County need Kansas Holistic Defenders.
Cortland Davis.
Good evening. The last time I attended a meeting was several months ago, and there was zero mention of another option. The vibe was more of what we have now works, let's not change it. Now there's a deadline. Now let's talk about conflict of interest and whistleblowers. Now let's hold up magnified poster boards listing why Mr. Natale is not qualified to serve we the people. Why now, when just some months ago, what exists was good enough?
I showed up to support KHD because I recognize the fact that the current way of doing business is flawed in many, many ways. This because at the age of 19, I experienced these flaws in Douglas County personally. I won't go into all of my business, but I do know that I showed up to court on more than one occasion. I do know that although some of these attorneys probably weren't practicing law then, that I went to several appearances and never once met my attorney. I do know that I felt isolated. I felt alone. I felt uninformed. I felt misled, misguided. I felt a lot of things that nobody in that position should feel, because I did deserve to have someone represent me who actually cared about me. I didn't get that. So now today, at a glance, it seems that the folks that don't support KHD simply want to continue the status quo, which again is flawed, as I said, in so many ways. Is it money? Maybe. Is it status or political? Possibly, maybe. Honestly, to me, it's lip service. Words shaped to encourage folks to feel like change is necessary, yet never really change much at all. It's talking reform, and I will tell you, I'm tired of that word, reform. It's another way of saying, let's change the optics, yet not change the reality. Why? At this day and age, with everything that is going on, we have all the power in the world to reimagine, to reinvent, and to make profound changes to these systems. I'm not going to rail against these attorneys. Like so many folks, they are part of the system that don't realize that the system doesn't work because it still works for them. It's just a status quo. I want to leave you with a quote that might explain some of that behavior. It's from someone I know quite well. A campaign is not just strategic and in its external goals, but strategic in the sense of how it shapes us as we do it.
Thank you, Mr. Carter. Your time is up. Thank you. Mr. Davis, sorry about that. PJ Carter's next.
My name is PJ Carter, 1505 Indiana Circle. Let me start with saying that I have 2 federal felonies. I've been shot 4 times on 3 different occasions. I struggled to survive in what we would quote unquote call the poverty life since I can remember. Check to check, day by day, et cetera, et cetera. I have an associate's in building technology. I have a bachelor's degree in intermediate studies, and I'm pursuing my master's degree in social work. I also sit on the board of KHD. As a member of this community, if I have a say-so in our public defense, I would like the quote unquote oversight, management, and direction to have more diversity than just the minds of those of our attorneys that we trust our livelihood in. Because there's more to that experience once you're, in my experience, have been kidnapped by the system. Referring to my notes here. I'd like it to go on record that as far as KHD, as a board member, and a member of this community, I truly believe that we're going to do this work whether we get this contract or not. And to double down on that, we've been doing this work for the past few years. I can attest that if someone comes to Sam, which I've brought plenty of folks to, he will represent them for free to the best of his abilities or suggest and direct them to a certain space. And I would just like to end with, being that I have a minute, that I feel like these conversations have been had before. We've been here in this meeting before, and we felt good about the direction we're going to. And if the attorneys in this county would like to be a part of the future of public defense in this county, that they should apply at KHD like the rest of the attorneys have. Thank you.
Joel?
Good evening, commissioners. My name is Joel Gallegos Jr. I live on 1934 Naismith Drive. And I'm here to speak in support of Sam's proposal and the Kansas Holistic Defenders. Disclaimer before, like the LJ world needs to write an expose about me. I voted for both of y'all. I really love your commitment to changing the criminal justice system here in Lawrence. And, you know, to what Jennifer said, you know, as a voter, I'm here to hold you guys accountable for that. And, you know, I volunteered my tail off for your campaign because I thought, you know, this would be a real instrument for change here in Lawrence. And this is the grand opportunity, you know, with the Holistic Defenders. And it's something I would love to see here in Douglas County implemented. You know, back to what Santiago was saying in regards to like the Douglas County Defense Service, or I forgot, was like, they're like one sentence answer to equity in regards to like what they're going to do here in this county. And, you know, how you spend your time is a good indication of how much you care. And so to see that one sentence there was not a reflection of what we as voters want to see here in this county, especially one that prides itself on the equity and diversity that we have here. So I hope y'all vote in support of Kansas Holistic Defenders because I think it is the best way to proceed in terms of public service. Thank you.
Elise?
My name is Elise Higgins. I live at 2218 Vale Way. Like Joel, to prevent any whistleblowing, I did work for and donate to 2/3 of your campaigns. And I want to speak to the will of the community. This community has clearly demanded the institutional public defender's office that the Kansas Holistic Defenders have proposed over the course of the past 2 years. The process has been long, democratic, and transparent, with no attempts to hide or obfuscate information. Commissioners Portillo and Reed, as you know, you garnered historically high voter turnout and unseated an incumbent on the promise explicitly made of a public defender's office and a commitment to addressing the ways that our criminal legal system fails to create justice for, and often most of the time harms, Black, Indigenous, and people of color and working class people. More recently, public comment at a forum on the creation of a public defender's office for felony convictions garnered an overwhelming amount of public comment in support of public defense compared with the current system. It's important to note that at that forum, defense attorneys representing the status quo said that racism in our legal institutions and processes is essentially inevitable and impossible to eradicate, and that any attempts to do so were based on false promises. But we know from peer-reviewed evidence that justice reforms in other cities have shown that this is not so. We don't have to accept that pessimism from that forum, nor the sheer laziness evidenced by the lack of response to equity questions in the Douglas County Defense Services proposal. As the author Ursula Le Guin says, any human power can be resisted and changed by human beings. Commissioners, you have both an opportunity and a mandate from the community through your election and ongoing activism to use your power and act boldly to change our institutions so we can live in a more just community. This county can be a place where our rhetoric matches our actions. Please vote for the Kansas Holistic Defenders proposal. Thank you.
Melinda?
Good evening. I'm Melinda Levon. I live at 539 Ohio. I've lived here for almost 26 years. Full disclosure, I volunteered for both of the Shannon's campaigns, but I actually live in District 1. And so I'm actually here to appeal to you as my district representative. I also worked on 3 campaigns this last year, and I'm taking projects for 2022 and 23. I have a little bit of personal experience from 6 years ago, almost 6 years ago, when my oldest son murdered my mother, and he was assigned counsel through our public defender system. And the individuals were excellent attorneys and honestly gave my father especially more care and kindness than the district attorney's office did. The DA's office really didn't seem to understand what to do with a family that the criminal and the victim are all the same people. That was really frustrating, and I look forward to seeing our new district attorney in their office and how they handle victim services. So, are the attorneys involved in Mike's proposal good, highly qualified attorneys who are also good people? Yes, absolutely. That's my personal experience. However, they didn't ask if we needed other services. They never did any warm type of referrals, because it's also not good enough to just say, hey, you should talk to so-and-so at Douglas County, whatever office, and look into this thing. You actually have to walk people through a process. And that's something that Kansas Holistic Defenders has actually planned on with that advocate position. My biggest concern across these 2 proposals is that anybody that's going to set up an inappropriate board structure that is not in the spirit of public service whatsoever, and also propose up to a $400 fee for poor people, that tells me that the people that wrote that are culturally incompetent to serve poor people. That's not acceptable to even bring up these types of ideas. It really demonstrates where they fall when it comes to understanding poverty and what people need. And I don't think that this system should continue. Thank you.
Thank you. Ben Woods?
Good evening. My name is Benjamin Woods, 933 East 21st Street Terrace. My brother had what he called an attorney that was appointed by the court for some charges he's currently dealing with. Charges that started in July. He has spoke with his attorney maybe 3 times and met with him 2 times. He doesn't return calls and messages. He didn't show up for an appointment they had the other day. My brother have health issues that's keeping him from working and have no income coming in. How can he afford $400? Knowing that if I call KHD, getting great representation and not having a price tag hanging over my head means the world to me. I don't think the system we currently have in place is working. His girlfriend sent a certified letter to the judge, the DA, and his lawyer admitting that she was in the wrong. They respond, you can go home if you take this two-year diversion. Like his friends tell him, Every time he talked to them, man, you not back home? His response is, nope. They respond is, it's only because you Black. These are his white friends speaking. The system is very unfair. I think KHD can help fix it. Now, Sam don't know my girlfriend from a fly on the wall. She's the one that's dealing with the eviction from the trailer court. It's because they don't want to take care. He stepped in. How he found out, I have no idea. I don't know where he get it from, but he had no problem with stepping in and trying to fix this situation for her. I ask you guys to look down really deep and think about this when you make your decision. I'm not a fan of the system that's going now. I've dealt with the system before. They tried to railroad me, but unfortunately I had the money to fight it. They drug it out for a year. I missed jobs that was paying $30 and $40 an hour simply because they drug this out so long. That's all I have to say. Thank you, guys.
Thank you. Kai Hamilton.
Hi, my name is Kai Hamilton, and I work with a tenant group here in town. I probably spend 8+ hours of my week listening to tenants in crisis in both the KC metro area and Lawrence. And these people are going through like some of the hardest times of their life. And on top of that, they have to face a courtroom completely empty and alone. In Kansas City, we have a small group of legal staff that we can refer for representation, but when we started work in Lawrence, we had no such thing. When I first talked to Sam about this, he had never done any kind of eviction work, but quickly stepped up and has done numerous pro bono cases. All of them that he's done for the tenants we work with have been pro bono, and he has gotten all of them dismissed. You've heard some of how that has impacted some of the people here today. But it's so important for these tenants to not have an eviction on their record as they go look for future housing or for them to be able to stay in their home. Poor and working class people, they need a champion, they need heart, and somebody who sees how their life will be dramatically altered by the charges that they face. And Sam has proved over and over again to have this passion and heart for these people, and that he will champion for them to the best of his ability and knows how to win for them, even when coming from lack of experience. This also could help create the KHD a way for a right to counsel campaign, which is so important for all the reasons I've talked about. Tenants really need representation, both for their own mental health reasons, but also because it helps them stay in their homes by overwhelming numbers. Up to 90% of the time when representation is present, the cases are dismissed. Through listening to tenants over the past year, I've learned more about the systematic issue of commodified housing, and more than any of my research in my past 4 years of schooling could have ever taught me, and that's by hearing their stories. It's been really clear to me that the people closest to the issues are the one who should be providing the solutions. So it's really concerning to hear the opposing side here come up and say that they think lawyers are still the experts in this system. Sam has provided multiple people here today who have been through the system that have that personal experience and that personal expertise. But I don't know if any of them have ever spent a night in jail. So, you know what you gotta do.
Paula Martin.
I'm Paula Martin. I live at 1514 Stratford Road. I've lived in Douglas County since 1971. I've been an attorney and a judge for 40 years. I don't even know where to begin, but the first thing I want to ask is to delay a decision on this. A lot more research needs to be done. The study has a lot of unanswered questions. The procedure has been flawed, and we need some transparency, and we really need to get back to a fair process. I want to address a couple things that seem to be misinterpreted by a lot of people, including in the Facebook post by Mr. Natali. No board member wants compensation. And contrary to Ms. Anderson's statement, certainly never to be paid by a defendant. There is no request to require anyone to pay $400. There's a statute that requires reimbursement if able to pay. The ability to pay is up to a judge and is often waived. I heard some troubling things during meetings with the commissioners, quite frankly. That experience and ability really wasn't important. It's a misdemeanor you can learn on the job. That's not what I would want. More troubling, it was said, well, if I needed a lawyer, I'd hire Shay or I'd hire Julia. So given the choice, which in this instance means money, you could have an experienced attorney. And in fact, it's one of the attorneys for DCDS. So experience does matter, particularly in this instance when it's you. All the collateral problems that everyone seems to think exist in misdemeanor charges don't occur unless there's a conviction. Again, a reason to have an experienced attorney. You don't lose your job, your housing, your family when you're charged with a misdemeanor because you are going to get an OR bond, most likely, or a summons so that you can self-report to jail. At last count, 7 out of 154 inmates in the Douglas County Jail were pretrial misdemeanors who had prior failures to appear or criminal records, so they did not qualify for an OR bond. If these issues do exist, these attorneys for DCDS know how to address them. So if you want to avoid all of these collateral issues, and that's what everybody here wants to do, you need experienced lawyers. We've criticized that there is no advocate. There is an advocate. They're called a lawyer. That's the lawyer's job. The last thing I want to say is impartiality. In meetings with DCDS and the commissioners, I have little faith that an impartial decision can be made. Comments were made that if Mr. Clark speaks to a person in power like this, how does he speak to his clients? Another comment, because of campaign ties and contributions by Mr. Natali, there's no transparency. And again, I have little faith that it can be impartial. And finally, when a member of the
Thank you,
commission
Ms. Martin. Your time is up. Stan
calls
Haslett,
Mr. Clark a racist and a racist asshole, I have no faith.
your
at all.
time is up. Stan Haslett.
Hi, I'm Stan Haslett, 2720 Princeton Boulevard here in town. Little background about me. 2 months ago, I retired from the disciplinary administrator's office. I worked for the Kansas Supreme Court. I investigated and prosecuted lawyers for violations of the rules of professional conduct. And as important as that in my job was fielding questions from lawyers about what their ethical responsibilities were. I considered that more important, actually. I am a board member for the Douglas County Defense Services. I never wanted any compensation. First time I saw that, Paula and I talked. Actually, Paula and I practiced law. I don't know if I should say how many years ago it was, but it was 40 for me, 35 for her. We have plenty of time on our hands now because we're both retired. I want to do this because I think I can offer a good service to this group. I know I can offer a good service to this group. I am here because of my confidence of these 7 attorneys, local attorneys. And you heard about their experience. I mean, they're all qualified to handle the highest level felonies versus one lawyer in the listed group that you know about. You don't know about who they're going to hire. You don't know what sort of experience they're going to have. You know, to my way of thinking, if you think you're going to get for $65,000 2 attorneys who are competent and have the ability to handle felony cases, I just don't see that happening. My experience with public defenders' offices have been, they're great. People go in there with good intentions. If they're really good, you know what? They go someplace else where they can get more money. That's just a fact. These lawyers, these 7 lawyers are competent, they're experienced, they're ethical. I'm really kind of baffled by this holistic model because it's just a new word for what lawyers did, what I did 35 or 40 years ago. It's a new word. I mean, these 7 lawyers do that in every case they have. So to indicate that this is some kind of new model, this is just new language for what lawyers have always done. and what they've been required to do, because that's what the rule on competency requires them to do. And finally, I would say, I'm looking at this work report, this work final report says, in addition to the information above, the work group recommends that the following information be collected and analyzed. I'm not going to list all the things that they suggest that you consider. They also say issues for further consideration. I haven't heard these things being discussed tonight because that hasn't been done. So I too would urge the commission to delay this vote to get all the information that they need to make the appropriate decision.
That is the end of folks who had signed up. Is there anyone else in the courthouse who would like to make public comment? We will transition online. Jill, will you, or Sarah, will you go through folks online for us?
I think I volunteered to do it. So hold on, let me turn my camera on so folks can see my beautiful yellow signs. And I will move the top person on our panel, Melissa Styler. I'm sorry if I get your name wrong. I've promoted her to the panel. Melissa, you can unmute yourself and begin your public comment.
Hi there. Chair Portillo and members of this commission, thank you so much for the opportunity to offer comments today. My name is Melissa Styler and I live at 600 Indiana Street. I work at a Kansas nonprofit where I dedicate myself to supporting the health of our communities. I vote in every election and I would generally call myself a good citizen. I've also been arrested and faced criminal charges on a few separate occasions. Thanks to public defenders, I had the support needed to get these wrongful charges dropped, and I offer my story to express an example as to why I urge this commission to support the Kansas Holistic Defenders proposal and to reject the Douglas County Defense Services proposal to ensure that our fellow Lawrencians can seek the same support that I've been so lucky to receive before moving here. Like many Kansans, I was raised working class. Our family sometimes struggled to make ends meet. On numerous occasions, we had one or more of our utilities shut off if my parents couldn't afford to pay the bills while waiting on their next paycheck. So I have personal experience and a real passion for the need to have affordable utilities and the difficulty to pay them even when you're working full time. Years ago, a local energy company that has now been merged with Evergy requested to raise rates. That would impact my community and make it harder for people like my family to keep our utilities on. I worked with members of my community to urge the energy company to withdraw the request to raise our rates, and if they refused, with our local government to reject their request. With respect to the honorable American tradition of free speech, we spoke up just like all of our folks are doing here tonight. We wrote letters to the company, to our elected officials, and to local media. We engaged in peaceful protest by holding a rally outside of their facility. My job at the rally was to pass out flyers about our cause to those who walked by. And a worker came out of the facility and called me over to ask what the rally was about. When I walked over to him to hand him a flyer, I was arrested for trespassing. I didn't even know that I had crossed the invisible line from public to private property, but regardless, I was handcuffed and brought to jail. Arrests are often that arbitrary, but luckily I had a wonderful attorney who was able to get the misdemeanor charge dropped. But let's look at the circumstance under both the Holistic Defenders and the Douglas County Defense Services proposals. Under the Holistic Defenders proposal, I would have been assigned a public defender that I am confident would be dedicated to providing the highest quality defense for me. I appreciate that their proposal shows the training and accountability process their defenders would be a part of, which is uniquely different than solo private practitioners. I appreciate their team model, which includes investigators and client advocates that are able to look at the entire picture of their client's needs. I especially appreciate that regardless of my ability to pay, I would have received the same level of quality care. Under the Douglas County Defense Service proposal, which is an appointed private counsel rather than a public defender team, this is not the same level of accountability. In fact, the appointed private counsel model has been shown to be less collaborative and have worse results for their clients. Approving this proposal would likely offer less effective defense, and one that I could not even afford. At the time of my arrest, I was literally fighting to keep the lights on in my house. A $400 fee may as well have been a $400,000 fee when you are living paycheck to paycheck.
Thank you. We really appreciate your input.
Thank you.
Commissioners, I'll move over Emily Galvin Almanza. Emily, you can you're in the panel, you can unmute and there you go and provide your comment. Thank you.
Thank you so much for giving me an opportunity to comment. My name is Emily Galvin Almanza. I am actually zooming in from Massachusetts today. I'm not in Kansas, not a Massachusetts person either. I'm actually from Iowa, but I'm the co-founder and co-executive director of Partners for Justice, a nonprofit designed to create collaborative wraparound defense in every county in America. We are extremely excited to be working with Kansas Holistic Defenders to ensure that they are best supported in providing the full suite of advocacy that they've described. I want to just make 3 really quick points since we've all been here pretty late. And they are as follows. We've heard a couple people get up and say that the enmeshed penalty work or the collateral consequence work, the housing work, the benefits work, the education work, the job search work, that's what an attorney does. And like, bless you for saying so. I am a former public defender. I know that's what every attorney wants to do for their clients. But as someone who now trains non-attorney advocates around the country in 12 different locations to do this work, I can tell you it is a separate form of expertise. The advocates who work on this broad array of social service stabilization are specialists in and of their own right. And I, who've been in this for over a decade, would still need to rely on their expertise when it came time to deal with an incredibly complex benefits issue, back rent seeking, access to housing under emergency circumstances. It's simply impossible for one human being, no matter how smart or expert they are, to handle such a broad array of subject matter, which is why we are excited to be training and bringing advocates to defenders around the country. I would also add that the real intent of this work is to choose office partners that can be regional models. Kansas Holistic Defenders to us has the potential to become a flagship, a model not just for the state, but for the Midwestern region of what is possible when defense is properly resourced, such that they can become an engine of not just great legal services, but opportunity and equity, and in fact, public safety. Finally, I would point out that when we do that, when we leverage all of the resources that the defense needs to be great, we are offering to people, some people we've heard from tonight, the tools that the privileged normally employ when they encounter the legal system. We are taking the tools of privilege and distributing them such that race and wealth no longer determine legal outcomes. So I'm proud to be partnered with Kansas Holistic Defenders for that.
I will move Rick Kagan into the panel. Rick, you're in the panel. You can come off mute and begin your public comment.
Thank you, members of the commission. My name is Rick Kagan. I live at 301 Wagon Wheel Road in Lawrence. I'm an advocate for individuals living with serious mental illness and substance use disorders, having previously served as the executive director for the National Alliance on Mental Illness in Kansas for over 12 years. During that time, we fielded hundreds of calls each year from individuals living with serious behavioral health conditions and their family members, including calls from Douglas County. And a significant portion of those calls focused on individuals facing criminal charges. As those conversations shifted to court dates, it was generally clear that legal representation was an issue, and callers would be anxious about an imminent hearing date for which the court-appointed attorney had yet to meet with the client. Calls to the attorney were often not returned, and the result was missed opportunities to provide essential information related to the accused defense. So all of these experiences point to the value of having a dedicated public defender in communities like ours to ensure the best possible representation for individuals in the community. I believe that Kansas Holistic Defenders clearly represents the best and most cost-effective option between the two proposals, which the commission is considering, and I strongly encourage you to enter into an agreement with them. They are committed from the outset to meet with their clients before first appearances, and their team approach will provide the best outcomes for individuals facing charges in the county. This includes making the best use of community resources to support individuals in the justice system. And by contrast, the competing proposal before the commission is more costly, would lock the county into an expensive 5-year contract. And beyond the contract cost, the DCDS proposal would charge the county for extra services, which are built into the base cost of Kansas Holistic Defenders proposal. DCDS group is opposed to the creation of a public defender program for felony cases, which Holistic Defender supports, and that includes broad support in our community for this, for creating that public defender system. And so this lack of support for a public defender system, to me, is an indication of their competing economic interests. The most disturbing aspect of the DCDS proposal, which we've discussed tonight, is this $400 fee. I think there's serious questions about what their intent is, but it is certainly antithetical to the purpose and need for a public defender system, and it would compound issues for the justice-involved population, would weigh most heavily on persons of color. The proposed fee structure would also create a perverse disincentive for effective representation.
Thank you, Rick.
Your consideration of this, of these comments, and encourage you to support.
Thank you, Rick. Your time is up.
Commissioners, I will move Greg Robinson into the panel. Greg, you're in the panel. You can come off mute and begin your public comment.
Yes, thank you, Greg Robinson, 3116 Trail Road. I have a few comments. I may come at this from a different perspective than things that have been discussed tonight. I'm bringing this from a perspective of a taxpayer in Douglas County. One of the things that astonished me tonight was some of the questions asked by this commission. It seems to me they really don't understand how this system works. And the information they've been provided by, I guess, any focus group or anything else, they certainly don't understand how it works. The process of the transparency issue, well, actually, as the taxpayer, does the county, well, I heard a comment made about house arrest and things of that nature. It appeared that the commission doesn't understand that house arrest is free. GPS for pretrial release and for sober link is available, paid for by taxpayers. Drug testing paid for by taxpayers. Bus passes provided by taxpayers. Funding for housing, utilities, treatment services, and prescriptions. So we are already doing much of this already. The proposal by the Holistic Defenders is just duplicative in its entire nature. We as taxpayers are already paying for every service that is being discussed this evening. What could be done is a limited representation agreement with an attorney to be at first appearances and hand them a sheet with all the services available to them. End of story, done. Keep the panel as it is. Now the person on first appearance understands what services are available to them from the beginning. Another issue is that's not been discussed this evening is a legislative solution. We talk about this from the end downstream process. We talking about after being accused of a crime, after being arrested for a crime. And then now we're going to provide counsel and all these services. What has this commission done to reduce the misdemeanor offenses that are currently on the books? Have you looked at removing the famous, his tag light was out, the license plate light was out, the blinker was out, windshield was cracked? These are all things that usually go to the poor, not people who drive Teslas and things of that nature, or Hummers around town. So if we want to really get down to business and fix this, then get rid of these statutes, get rid of these ordinances. But we won't discuss that because we just want to pay all this money. The other thing I want to make point is the legislative process is fine. Where's the discussion with the court? We have 3 branches of government, and the justice system, judicial branch has been totally cut out. Judge McCabery, chief judge, makes the decision about the panel. You provide the payment. I will say this.
Thank you, Greg.
My
Your time is
went
up.
very fast. My
Thank
time
you,
went
Greg. Your
very
time
fast.
is up.
Yeah, okay, sure it was.
I'm moving Jasmine into the panel. Jasmine. Jasmine, you're in the panel. You can come off mute and provide your public comment.
Hi, sorry, my computer took a minute. I'm not going to turn on my video because my internet is being really slow. But my name is Jasmine Bates. I live at 809 Massachusetts Street, Unit C. I'm here to speak as a community member in support of Kansas Holistic Defenders. It's pretty clear to me that what we see tonight is a proposal for a public defender's office from KHD and then an attempt at a counter proposal. I say an attempt because it's completely ridiculous and out of touch that a $400 charge for clients was included in the DCDS proposal, while the equity questions were completely glossed over. As earlier commenters have made clear, $400 is out of reach for those in need of indigent defense. It would be out of reach for me if I needed defense. And the importance of addressing equity in the criminal justice system cannot be overstated. It's offensive that an application was submitted to our commission without complete answers to the equity section. I don't care that applicants have since said in comment that they don't need fees or board member payment because it is included in their application. To me, these details of the DCDS proposal and the way that questions were handled tonight shows that those making the second proposal are either not actually interested in serving the need, did not spend adequate time and effort on their application, or are just out of touch with the situation of those they intended to serve. In contrast, Kansas Holistic Defenders proposal is robust and complete application. It's based on current best practices and research, and they have individuals who have lived experience both on their board and they're providing public support tonight. It's clear from the amount of free labor that KHD has put into selecting a board, establishing a nonprofit, and raising outside funds that this application comes from individuals driven to see quality indigent defense for our community members. I hope that the commission will support KHD without further delay. The idea that more research needs to be done and that this process is unfair is ludicrous to me. The research is there. Sam cited it in his presentation and has been meeting with the commission for months. There's been ample time for applications, as there has been ample time for KHD to become an established nonprofit with a board, bylaws, successful fundraising, and community support. So lastly, just thank you, commissioners, for your time. And thank you, Sam, and everyone at KHD for the time and effort that you've put into preparing to serve our community in this vital way.
I'm moving Kirby James Evers into the panel. Kirby, you can come off mute and provide your public comment.
Sure. Hello, my name is Kirby Evers. I live on 3032 Havrone Way. I was born, raised, and will probably die here in Lawrence. I'd like to quote the immortal John Brown. Never forget the poor, nor think anything you bestow on them be lost on you. COVID has hit our communities and our neighbors. I've known plenty of them to have lost their jobs and need all the help they can get, even going through our court system. In such hard times, everyone deserves a fair shake. And in a country where half of Americans are living check to check, we need every bit of help to get that fair shake. Both groups here have presented two wonderful proposals. However, it is only the holistic defenders who have shown a true drive to communicate to the people of our community. The money in play cannot be handed out so flippantly. And if the DCDS does not think our neighbors are worth their time, then I can't say that the DCDS is worth all that much to us. There has been one side here who has been calm, civil, and avoided embarrassing, petty mudslinging, and that side is the holistic defenders. The vote should not be delayed. We need solutions, not half-baked proposals. Thank you very much, and have a good night.
Okay, I'm going to move Teresa Woody into the panel. Teresa, you're in the panel. You can come off mute and provide your public comment.
Thank you. Teresa Woody, 211 East 8th Street. I am happy to be here. Thank you to the commissioners. I'm the litigation director for Kansas Appleseed Center for Law and Justice, and I'm here to support KHD's proposal. In doing so, I do not denigrate any of the talents and dedication of the lawyers from the DCDS panel, but it has been proven study after study that institutional public defender's offices are the best and most efficient way of dealing with the indigent folks who need representation. They are more complete, they are more focused, and they give better representation to those individuals. When you hear Mr. Clark's comments about how they would handle their, how they would juggle their calendars if they had other clients to deal with, it's clear that the best intentions would not lead to the same good effects of having an actual public defender's office that is really concentrated on misdemeanors. With respect to institutional public defender's office, it's very clear that they have much more coordination. And here in Douglas County, we have coordinated institutional prosecutors' offices, and the defendants in Douglas County deserve no less. Thank you.
All right. I'm moving Cooper Overstreet into the panel. Cooper, you can come off mute and provide your public comment.
Thank you. My name is Cooper Overstreet. I'm an attorney here in Lawrence, and I'm also a board member of Kansas Holistic Defenders. And I'm here to first thank the County Commission and the Indigent Defense Work Group for all the work that's been done over the last year, and really highlighting the importance of the discussion surrounding indigent defense and quality of indigent defense. And not necessarily quality, but structure of indigent defense. Kansas Holistic Defenders is a true institutional defender's office, meaning that it is a teamwork environment. It's a collaborative environment. I'm a criminal defense attorney, and I know from that work that this isn't a go it alone profession. We're going into court every day, going up against teams of prosecutors, teams of police officers, and an entire system that is set up to convict our clients. You can't fight that alone. You need a team, you need a collaborative effort. And that's what true institutional defense is. And that's what KHD is. In the time that I've been on the KHD board, I've seen just how it interacts, not just in the legal system itself, but also in the community. I mean, we're talking about an organization that has gone above and beyond to engage with community stakeholders, people with lived experiences who know about just how unfair our justice system can be, and folks who actually have experience helping people in that system. That's what true holistic defense is. KHD is an organization devoted to collaborating with those community stakeholders. And I want to touch specifically on a couple things involving things that have been said here about the experience level. Now, I am a member of the felony and misdemeanor indigent defense panel here in Douglas County. And I want to say that, and I think that's important because my colleagues in Douglas County Criminal Defense Services, who I respect, and they are good attorneys, they don't speak for everyone on the panel. I would stand to lose work if KHD came into existence, but I'm willing to have that happen because I know what indigent defense needs, and I know what an institutional defense does for indigent clients. KHD's gone above and beyond also to engage in an open, thorough application process. Folks have said, who are we hiring? Who works for them? We didn't go self-select attorneys. We are hiring attorneys. We have and we've gotten some very qualified applicants at this point. The average experience of those applicants of dedicated public defenders, 11 years experience. It's also a hiring process being led by Melody Brannon, who is the chief federal public defender here in Kansas, one of the most respected defense attorneys in the state of Kansas. And so we've done that. We're engaging that open process because we want to make this something that's foundational and transformative for Douglas County. And so I urge the county to consider KHD and fund us. And
Thank you.
Want to do. Thank you.
We have one last person that has raised their hand on Zoom. I'm going to promote Megan to the panel.
And just a reminder, as Megan's coming in, if anyone else would like to make public comment, please raise your hand now.
Megan, you're in the panel if you want to come off mute and provide comment.
Hello, my name is Megan Willison. I live at 801 North 7th Street in North Lawrence, and I've been a resident of Douglas County for 22 years. I'm here today to add my voice to the support of the proposal provided by the Kansas Holistic Defenders. I find that the Holistic Defenders model is the most comprehensive, the most sensitive to the circumstances and experiences of the client, and the model most likely to result in fair and dedicated representation and a reduction in recidivism. I don't feel that the proposal provided by the Douglas County Defense Services best meets the needs of indigent clients, in part because of the requirements of having the client pay for their own mental health evaluations, offender assessments, and attorney fees. Even if those costs are deferred until after the case is settled, the burden of those fees perpetuates the state of poverty that clients are already experiencing. I don't feel that the DCDS proposal properly addressed issues of equity or systemic racism inherent in our current justice system. And also, I simply see no real benefit to the county as a whole by adopting the DCDS proposal, only to the individual private attorneys who comprise that group. Douglas County should invest in a holistic defense model, and the proposal by Kansas Holistic Defenders best meets this need and at a lower cost than that proposed by the DCDS. Thank you.
Commissioners, no one else raised their hand in the panel for public comment.
Thank you so much. As we bring this back for discussion with commissioners, I do just want to check in since we've been going for another hour and a half. Would we like to have discussion? Do we need a quick break? What are folks feeling? Okay, let's move forward with discussion. I do just want to start off by saying thank you so much for all of you who are here with us in the courthouse or were here with us in the courthouse, and for those of you online for taking the time to go through this discussion with us and to make your voices heard. I think that when our community makes their voices heard, it adds to everything that we know that can help us make decisions, and it's an important part of this process. I do think it's also important to reiterate the process piece of this. So when we talk about kind of how processes come about, there is a process for our community partners funding, and that was the process that Kansas Holistic Defenders originally engaged. We are still working on what a process would look like to compare competing proposals, because this is a unique situation where we have two different types of proposals that are really trying to address a really complicated problem for our community. And our community has made clear that we want to address this complicated problem. I also think it's important to point out what the work group final report said when it came to data. We did say that we need to collect more data, but those data are from attorneys who are practicing. So that future research section is not, we need more data on what we think would make sense in our community. That future data section is saying that we need better data so we can assess the outcomes of the criminal legal system in our community. That work group report could not make an explicit recommendation because we had members of the bench sitting with us. We had really great judges giving input. And so we weren't saying this or that. We were identifying the issues that we heard from the community. We were sharing their research, and we were sharing data that we currently have and what kind of data we need into the future. So any discussion of future research or future data has to do with what our expectations are of our practitioners, whether we adopt an institutional model or stick with panel attorneys. I think there is an expectation of the county commission as funders, or at least 1/3 of the county commission as someone who decides on funding, that we need better data to help us understand how those county funds are spent and the outcomes of that system. That data piece should be built into any kind of next steps that we have. but I think there is a clear mandate for reform from our community when it comes to criminal defense. I also just want to point out one other process piece, that qualifications for attorneys are incredibly important. They're also completely outside of the purview of the county commission. The county commission is tasked with deciding how funds are spent. And as we talk about as a county commission all the time, budget documents are values documents. And we have made a commitment to criminal justice reform as a county commission. As Commissioner Kelly brought up, we've invested heavily in drug courts to make sure that they don't cost anything for folks going through them. We've invested heavily in a number of criminal justice reforms because that's the expectation of our community. So the idea that we wouldn't be investing in ways that make sense for our community, that's a problem. We need to make sure that we're putting our money where our values are. But what we do as a commission is decide how funding is spent, and that does shape the structures of things within our community. And so looking at what kind of structures we want. But it is up to the bench to decide the qualifications of individual attorneys. So we do have high expectations of any attorneys practicing in our community for being qualified. But it is not the role of the county commission to decide on qualifications. It's the role of the bench. And we have had a number of conversations, I know here in this chamber as part of work sessions, as part of our indigent defense work group, but also individually. I spoke with every single attorney and board member from the Douglas County Defense Services contract that reached out to me and had a number of conversations with them. I've spoken with a number of community members. So it is important that we play our role of collecting community feedback, hearing what the mandate is of our voters, and spending our money in ways, the taxpayer, the community money, in ways that really fit with the values of our community.
So I'm really glad we had this discussion tonight. I have been reflecting a little bit. When I came in, on another board I used to serve on, I really tried to make sure that whatever I walked in on that night, I really didn't have a decision made because I was interested in hearing from my colleagues. I was interested in hearing from the public about what their thinking was about it. And I'm really glad we got a proposal from DCDS to compare and understand what that group was thinking. Because for a time there's a lot of discussion going on about, well, there may be a better way to do it. Great, tell us the better way to do it. So, we only had Kansas Holistic Defenders there. And I think through the questions that were asked tonight and the discussion that was had tonight, it became more clear to me the direction that we should go. So I really think that conversation is good. That's part of the process. What we just did tonight is still part of the process. It's the most important part of the process. I think we have work to do when it comes to process here in the county. I think, Commissioner Portillo, you said at the beginning that, we opened it up to everyone. And I think that is the way that we conduct business now. But I think it would be good for us to talk about that, whether that's the best way to do it, because I think, we may have lots of competing proposals for lots of things. And I think we need to be maybe more clear than we were on this one about exactly what we wanted before we got proposals in. And I think that's work for us to do. We need to be better government. We need to be better representatives of the people who voted for us. And we certainly can improve on that. We can certainly improve on work groups and how we do work groups. I had a good conversation with one of our city commissioners just this week about how they do work groups. And I think we can learn something from that. And I think we can get better at it. So I think, those who say there's something wrong with the process, I'm with you. I'm part of that process. I own my part of the mess, and that we need to continue to work on that process. But I think the most important thing that I took away from tonight's discussion was this idea around change. And if we're going to use a different system, and I think we do need to have a different system. I do think that a public defender's office is very important. I support it. That I wouldn't have put $425,000 in the budget if I didn't support it. So I think it's a good thing. But often change comes from actors who are outside of the system. And that can be pretty disruptive for those who are inside of the system. The three of us are inside of the system, the courts are inside of the system, and that can, you know, as you think about that and you think about who that is, and one way we can look at it is saying that the people who are currently doing the work aren't doing a good job. That isn't necessarily true. That doesn't mean that they can't do a good job in a different system, but it's hard to see when you're in the system how it might operate better. And so sometimes it's really good if somebody comes from the outside and says, you know, there's another way to do this. You might try it. And it's good for us to hear, and I think for the courts to hear, and for our entire community to hear that there's another way to do this. And I think I really appreciate the thought process that went into that, the thinking that went into that, and our process tonight on hearing, you know, here's sort of the way we've been doing it, and here's the way we could do it. And I think that that's a good thing. And I'm fairly convinced and confident in my vote.
This Commissioner Reed, I think, well, I would agree with all of your comments and appreciate both my fellow commissioners' comments. I think to me, it's very evident and has been evident for some time, both in my role as commissioner so far this year, but I would say perhaps more impactfully in my role as an advocate in this community, working within a court system and seeing so many different situations play out in really harmful ways. And that the impact is always greater than the intent of the actors whom may have their best interests and best intent at play. And without a system in place and an institution, that is extremely difficult to have much confidence or continuity in. So that really colors my, I guess that's the lens through which I'm looking at this issue. For me, it has been a mandate of our community for some time to change the way that defense services are provided for poor people in our community, which, as has been pointed out multiple times, is 75% or more of folks that are charged with a misdemeanor are being represented by appointed counsel. That is the duty of the county to pay for and have their dollars invested in a system that serves those people in the most robust way possible. I believe in a teamwork model. I believe in holistic defense because my role as an advocate tells me that teamwork is, well, not to be so cliche, but what makes the dream work for some folks. It's really what creates opportunities and pathways, because it's a coupling of different skill sets that are complementary and that can work effectively together. So change is a mandate. I will say, and holistic defense is a model that I think there's an incredible amount of data and research to support, and I believe wholeheartedly in it. And the one piece that I'm a little stuck on, and I think it's just some nuts and bolts conversations that we need to have with our community partners at district court primarily, is about the client advocacy piece, because that piece is so important to me and I see such high value in it. I want there to be an equitable way in which we ensure clients who are appointed counsel, community members appointed counsel, have access to that. So I think we need to think through that and, I don't know, crack that nut open a little bit more and figure out how to address that equity issue. Because inevitably, well, we had part of the discussion tonight that it will come up, and I don't know exactly what the right answer to that is, but I'm interested in some more conversations with our district court and our bench about their perspective on those procedures and the sort of policies that can be put in place around that. So that's something I wish for us to workshop a bit more, I suppose, in that holistic model. But I would agree with you, Commissioner Kelly, that tonight's discussion in totality makes it very clear and evident for me that that change is necessary, and that the notion of, well, have you tried it this way? There's a model for that, is a compelling one, and it is one that I think that our community has charged us to move forward with and evolve that process.
Yeah, I'm glad you brought up the services and the client advocate, because I think that's something that has been hanging me up for the past 2 weeks since we first started talking about this, is like, how do we do that? But I'm pretty confident that we can do it. I really appreciated Sam's answer about it, that we need to look at it maybe just a little differently than we are now to make sure. And quite honestly, his response showed me that he's still flexible on it, that it's a process that we're going to have to work together on, that we're going to have to work with the courts on. And so when I think about it, it is super tempting. It is really tempting to want to sit here in this position and say we have to have all the answers before we can move forward with something. But I know that that's sort of naive, that we would have all the answers, and that we sometimes need to push forward on something, having faith in those partners who are working on it that will work it out. Because we're a government entity, we probably need to work it out in public. We need to have discussions about it. So we can talk about what that means tonight and how we move forward tonight. But I think that and the conflicts, and quite honestly, I did a little back of the napkin math, and I think the conflicts are not going to be as expensive as maybe I initially thought, just based on some of the answers I heard. I think it is going to be a cost for us, and I think it's going to be a bigger cost down the road. Maybe bids will be here and we can have those conversations, Heather, and we'll be closer to that dream that we have. But, I think we have some time before that really starts to become an issue for us. So I'm less concerned about that than I was coming in. And let me say one more thing, sorry, about the qualifications. So I took issue with one public comment that I want to address. You don't have to be paid a lot of money to do a good job. And there are a lot of people out there who do an amazing job without having to be paid a lot. And the idea of what you're paid as assessing your value in your profession is really misguided. And I think we need to honor that those attorneys with Kansas Holistic Defenders will have passed the bar, so they have those qualifications. They'll be working with the judges. It sounds like they have a ton of support from other organizations, which, while they may not have all the qualifications, I mean, that's part of the system, that's part of the status quo. Those are some of the things that we need to challenge. I'm not saying experience isn't important, but experience isn't the only thing that helps us become better.
I really appreciate that point, Commissioner Kelly, a lot. And I'm going to piggyback off it a lot to say that something that really sticks out for me about the conversations we had tonight and the public comment in particular, and just something I've been reflecting on in recent weeks, in my role as somebody who's had all these client-facing relationships and seeing the direct impacts and helped folks try and navigate that. I hold all these stories of other people's lived experiences that are not my own and not mine to share. And I can talk about themes of things I see happen, but I just want to really appreciate, I have a deep appreciation and gratitude for the folks that came tonight and gave comment about their own lived experiences and the impact that it had. And I mean, some of those folks have left already, but those are really impactful conversations for me. And I am grateful for people being vulnerable enough to share the impact, share the experiences of isolation and being misunderstood and left behind and ignored. And that obviously that's not every person's experience of a private appointed attorney. But those experiences are not few and far between, and they matter. And they are indicative of a fundamental flaw in our system, I believe, that does not account for those lived experiences. So I just have a deep gratitude for folks that were willing to come and share that. I've been reflecting on how I'm maybe, owning part of the process was, and how this process was not perfect, and we need to figure some things out at the county level moving forward. For me, I think the part that I wish I would have thought of earlier is how do we engage community members with those lived experiences in our county with the current system, and what that impact has been like for them, what worked, what didn't work, and I, to some degree, wish that there had been more emphasis in our process on how to gather that information. And for me, like I said, I can take it for granted because I hold so many of those stories in my mind from all my experience, but can't speak to them, and don't always consider that other people may not have that degree of awareness or understanding of those people's perspectives and the harm created by failures in a system. So I'm grateful for that. And I also just want to compliment that Kansas Holistic Defenders, in my experience, with watching them organize and research and grow in this year, have really put that at the forefront, and we heard from many of their board members tonight, some of whom have lived experiences. And I think that the board reflecting that is crucial to legitimate accountability to the community, and the sort of informed experiences of people who are being impacted and have all of those collateral consequences we've been talking about. So
I just want to say thank you to both Commissioners Kelly and Reed for the kind of owning our space in the process. I also think that this is part of an ongoing conversation. So ongoing conversations about our own process, but also ongoing conversations about the role of local government in these conversations. So I think that Commissioner Kelly, you've brought up multiple times, like how would this interact with the bids office? We heard from Heather Cessna that bids already has its hands full with felonies, so we have to be careful with all of those pieces. I think it's also our role as citizens and community members to continue to push our state to do better, and to continue to push our state to fund public defense across the state, and to really keep asking questions about this whole felony misdemeanor divide, because it's really gotten under my skin. And it's one thing that I promise I will be asking a lot of questions at the State House about for a long time to come. So I think that there is broader systemic reform that we need to have across our state. And this is an opportunity for us to start some systemic reform here at home locally. And I am really excited for that possibility.
So I'd like to make a bit of a suggestion of how we might move forward, if commissioners would be ready to entertain that. I would like to see our Kansas Holistic Defenders, because I'm getting the sense that that's where we'd want to go tonight. So correct me if I'm wrong. I'd like to see them work with our judges panel on how we do the client advocacy work. And I don't know if that's the right way to do it, to be honest with you. I'm not sure how to do this, but that client advocate part, I'd like to get a little more worked out. And if they could come tell us, like, this is how we think we're going to work it out. That may be a terrible suggestion, but I'd love to hear from other commissioners. And I just want to get us talking about how we move forward.
I don't think that's a terrible suggestion. I think that it's really important to think about the kind of on the ground logistics. I also think it's important for us to walk away today with a decision to move forward. So I think that that should be incorporated into yes, we are moving forward with Kansas Holistic Defenders, and it is not our role as a commission to write those contracts or to talk about that implementation piece. When our form of government, we have a badass administrator, She is good at her job. She has a great staff working with her on the actual contract piece of it. So I think that it's our role to direct staff to make sure that there is this collaborative relationship, working that out as part of the implementation process. I see that much more as implementation than policy decision-making and budgeting.
I mean, I think that makes sense to me, Commissioner Portillo. I guess I wonder how best to direct staff and then bring it back to a public conversation. And yeah, I mean, I guess that's really, wanting to basically lay out a plan and a timeline for how we are to do that.
Sarah, would you like to jump in on that?
Yeah, here's just an idea. I think some of the things that we've done through the community partner process have been to, we work on a scope of services and we try to outline what we can. I think if there is ever some sort of conflict or there's something that we need to continue to explore, obviously that's an issue we bring back to the commission if we can't come to some sort of resolution that's agreeable on how to proceed. Also, I'd say, we amend contracts, these community partner agreements throughout the year. We add a project, take a, something changes. So this agreement is a living document. So I'd say that to the agreement piece. But what I hear is what I think is part of the issue is there'll be, I think there's a need for client advocacy in addition to what happens at KHD. I think we need to sit with KHD, talk about capacity, what's possible, what's not possible, what is legal and ethical in terms of what they can do in that team. But I also know that our decriminalization of poverty work group is a part of our community health improvement plan that works closely with our criminal justice coordinating council, racial disparities work group, and the other work group that they had working on decriminalization of poverty brought forward as one of their recommendations, client advocacy in general. And I think that's a model that Jill serves on that group to go back to that panel and talk about what are the models for client advocacy? Who do they report to? What is appropriate? What's not appropriate? Or is there a need for additional services for client advocacy? And that's a conversation we haven't had yet. I think that could come back to the commission. There could be further deliberation on that. It gets into issues in addition to just court navigation, not necessarily advocacy. So I think we could still, depending on how the conversation goes with KHD, I think there's still more work there to do is kind of what I'm hearing from Commissioner Kelly. And I think we could certainly bring that back to the commission for further study, just to make sure that we are approaching, everyone's getting the same access to services. Am I kind of getting down the road you're headed?
Yeah, I mean, you're saying what I'm wanting to make sure is that everyone has access to those services and we don't create an inequity within the system as we're trying to address inequities within the system, right? And so, but I don't know how to do that. And I don't think I agree with Commissioner Portillo, we shouldn't be doing that. But I also think it's good for us to hear about it publicly in a meeting and how we're going to do that, because I think our community deserves to know, how can I make sure that I get that client advocate? If we think that's a value and that's something important that needs to be funded with our community's dollars, how are we going to do that? Because I don't have a sense yet as a way that we'll do it equitably.
I hear that as a value, and I think that's something as staff we can certainly take back and talk about how we bring that back to you with additional information.
It does sound like we are ready for a motion for this evening, though. And we are all hurriedly trying to pull up the motion. And I believe that I might be the fastest here. If I can get all the way to the top of the 69-page document. There we go. Okay, so I move to award institutional misdemeanor indigent defense services to Kansas Holistic Defenders for the 2022 budget and direct staff to develop a community partner agreement and additionally direct staff to have continuing conversations with Kansas Holistic Defenders and the District 7 bench about how we will consider court advocacy and bring that discussion back to the commission.
Second.
All of those in favor, please say aye.
Aye.
Thank you very much. We will move on to appointments. And I believe that we did get an email about appointments.
Yes, commissioners, late in the day, I did send you 2 appointments. I can try to pull them up if you're ready. They're reappointments for the Board of Construction Appeals and the Building Code Appeals Board.
Are we okay to move forward on these? Okay, I will make a motion because I have that email pulled up. I move to reappoint Rich Barr to the Board of Zoning Appeal and reappoint CL Mauer to the Board of Codes Appeal.
I'm happy to second both of those. I know both those gentlemen, they'll do a great job.
All of those in favor, please say aye. Aye. Thank you. We will move on to miscellaneous. Sarah, before we turn it over to you for miscellaneous, I did just want to point out that I didn't see the little government relations report that you mentioned in there, and I would love to see it.
I'll make sure we forward it to you, and then I'll attach it to next week's or the December 1st weekly memo.
Thank you.
Attached is partial memo regarding my update for the week. I do want to announce that we do have our quarterly judges luncheon this Friday at noon in person at the EOCA. And we had some of our staff win some really prestigious awards, and I'm really proud of their continued work on this. And it's great the sheriff's still here to help us share in this recognition. We want to congratulate Douglas County Director of Emergency Communications, Tony Foster, as he was named the 2020 Director of the Year by the Kansas chapter of Association for Public Safety Communications. And Dana D'Ericole, who was recognized for her years of service as well. Also, commissioners, we do not meet next week. So we will be taking next week off and we will be back December 1st. Do you have any questions for me? I was going to say one more thing that's been a long night. So do you have any questions for me? Okay, thanks.
I am sad that I will miss the judges luncheon this week. I will be attending the American Society for Criminology Conference and talking all about criminal justice reform. So just a long continuation. But please have a lovely lunch. I talked with Judge McAver yesterday and he said that they were going to order something extra good because I won't be there. But I don't have anything else. Do we have anything else from other commissioners? No. Okay, we are adjourned. Thank you.